Section 33 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Paul Waldrop of Waynesville, North Carolina. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2, Section 33. Chapter 6, Milk Producer Contribution Activity in 1972, prior to April 7th, the Justice Department antitrust suit against AMPI. By the end of 1971, the milk producers had received much of the favorable treatment from the president that they had sought. Low import quotas, higher price supports, meetings with the president, and the presidential address to their convention. But they had also been the subject of a great deal of unfavorable publicity in connection with their attempts to honor their commitment for contributions. In order to make additional contributions in 1972 without that attendant publicity, they recontacted Kalmbach and tried to develop a different procedure for those contributions. At about the same time, a Justice Department antitrust investigation of AMPI culminated in the filing of a civil suit. This action impacted upon the contribution activity of the milk producers, at first chilling their interest in making additional contributions, and, according to Kalmbach's testimony and other evidence, later, just prior to April 7, 1972, resulting in a last-ditch effort by AMPI to seek a cessation of the suit as a quid pro quo for more secret contributions to the president's campaign. A. The Justice Department antitrust suit against AMPI. In the late 1960s and early 1970s, the Antitrust Division of the Justice Department received a number of complaints from independent dairy farmers against MPI and then later AMPI, alleging that the cooperative had engaged in predatory practices to squeeze smaller cooperatives out of their markets in order to monopolize their markets. A staff investigation was initiated, which led to a recommendation for a grand jury investigation, leading to possible criminal prosecution. Attorney General Mitchell rejected that recommendation and limited the department's action to a civil suit, which was filed on February 1, 1972. 1. Department Staff Investigation and Recommendations. On February 23, 1971, the Justice Department authorized a preliminary investigation of AMPI's activities in the Dallas, Texas area, which soon expanded to a number of states in the central United States. Much of the original investigation was conducted by Rebecca Schneiderman, a trial attorney in the Chicago Regional Office of the Antitrust Division, who, after a several-month investigation, concluded that AMPI's activities were sufficiently anti-competitive to necessitate a grand jury investigation of the cooperative with a view to possible criminal prosecution. John Sarbaugh, chief of the Chicago office, concurred with Schneiderman and on August 11, 1971, requested authority to conduct a grand jury investigation of AMPI. The request was forwarded to the Antitrust Division in Washington, D.C., where it was reviewed and approved by a succession of officials, all of whom concurred in the recommendation of the Chicago office. These officials included Badia J. Rashid, Director of Operations for the Antitrust Division, Gerald Connell, Chief of the Department's General Litigation Section, and Robert Hummel, Deputy Director of Operations. After the approval, the grand jury's request was sent to the office of the Assistant Attorney General for Antitrust, Richard McLaren, where it was reviewed by McLaren and his assistant, Walter B. Comegys. McLaren consulted with Assistant Secretary of Agriculture, Richard Lang, to determine whether the Department of Agriculture objected to a grand jury investigation of AMPI, and Lang indicated that the department had no objection. Both Comegys and McLaren then approved the request, and on September 9, 1971, 1 week after the President had addressed the AMPI convention, McLaren forwarded a memorandum to Attorney General Mitchell requesting authority for a grand jury investigation. McLaren says he normally received a response from Mitchell on such matters within a week or two. When by October 29, 1971, 7 weeks later, McLaren received no response but had continued to receive complaints from milk producers about AMPI's conduct, he sent Attorney General Mitchell a second memorandum requesting authority for a grand jury and emphasizing those allegations that AMPI was continuing its predatory practices. 2. Attorney General Mitchell's actions. On November 30, 1971, in a departure, according to McLaren, from department practice, Attorney General Mitchell rejected the request for a grand jury investigation of AMPI. In a one-line memorandum, he instructed McLaren, "Per our conversation, I request that you go the civil route," thereby limiting the case to a civil suit only. Although Mitchell does not remember the conversation or even turning down a request for a criminal investigation, he acknowledged that the memorandum must have reflected his decision. And Judge McLaren has stated that he did discuss the AMPI case with the Attorney General on November 30th. Apparently, in the course of their discussion, the Attorney General expressed the opinion that the Justice Department would have difficulty obtaining a criminal conviction in light of AMPI's defense that a federal statute applicable to farmer cooperatives, the Capper-Volstead Act, exempted its activities from the antitrust laws, and that AMPI could claim they relied on advice of counsel. However, from the very start of the investigation, the Antitrust Division was cognizant of the provisions of the Act and the argument that the statute exempted AMPI from the otherwise applicable provisions of the antitrust laws. Based upon a long-standing Supreme Court precedent, everyone concerned had rejected that argument except Attorney General Mitchell. In response to a recent staff request, McLaren stated that Mitchell's action was unusual and that he could not recall any other specific instance in which Attorney General Mitchell turned down a recommendation from the Antitrust Division. McLaren further pointed out that, to his knowledge, Mitchell had no particular expertise in this area and had no information that was not available to the Antitrust Division. Of the various alternatives available to the Justice Department under the circumstances in the case, a criminal prosecution, simultaneous criminal and civil suits, or a civil suit only, the Attorney General's directive to McLaren limited the department to the minimum action which the government will pursue when the evidence indicates an antitrust violation. In interviews with Select Committee staff, some of the staff attorneys in the Chicago office who had concurred in the appropriateness and need for a grand jury investigation stated that they were disappointed and surprised at the Attorney General's decision. Aside from other considerations, the decision to pursue the AMPI case as a civil suit had an impact on the subsequent investigation in the case. Normally, investigation of a civil suit is conducted by Civil Investigative Demand, CID, a cumbersome procedure which moves very slowly if the person or organization under investigation resists the demand for information and documents. A grand jury, on the other hand, has more extensive compulsory procedures, including the ability to subpoena testimony and documents relative to the case from the party under investigation or from third parties. Recognizing the limitations of the CID and the apparent urgency of the complainants, and perhaps in expectation of resistance by AMPI, McLaren directed the staff to obtain, by interviews, any further evidence needed to prepare a civil complaint, in addition to that accumulated during the preceding 9-month investigation. These instructions were carried out, and a civil complaint against AMPI was drafted, which alleged generally that the co-op had violated Sections 1 and 2 of the Sherman Act. Among the specific allegations of the complaint, it was asserted that AMPI had 1. Depressed the price which its competitors could receive for their milk by loading the pool while protecting AMPI members from economic loss. 2. Agreed that processors who purchase milk from AMPI would not purchase milk from competitors of AMPI or would pay a substantially higher price for their milk than those who did not deal with AMPI's competitors. And 3. Agreed that some processors would not sell or deliver milk acquired from AMPI to other processors except as directed by AMPI. The complaint also alleged that AMPI had acquired competing processors and haulers, and as part of its base excess plan, forced its producer members to sign membership agreements forbidding the producers from competing with AMPI for a period of 5 years after terminating membership in the co-op. In late December 1971, the Chicago office sent a copy of the proposed complaint and a memorandum summarizing the evidence to support the suit to Washington. On January 18, 1972, following review of the case in the Antitrust Division, including the making of minor changes in the complaint, McLaren met again with Assistant Secretary Ling and showed him a copy of the proposed complaint against AMPI. Ling stated that he had no objection to the complaint and that he would advise the Secretary of Agriculture of McLaren's proposed action. McLaren then forwarded the complaint and fact memorandum to the Attorney General with an accompanying note in which he stressed AMPI's grossly predatory practices and strongly urged the Attorney General to approve the suit. On January 22, 1972, Attorney General Mitchell approved the complaint and sent it to McLaren with a note which said, "I suggest you get these people in before you file." McLaren says that Mitchell specifically directed him at that time to give AMPI the opportunity to enter into pre-filing negotiations. The committee received conflicting evidence on the regularity of undertaking pre-filing negotiations. Pre-filing negotiations are undertaken in an attempt to have the parties agree to a consent decree, which is then filed with the complaint in settlement of the case. While according to McLaren, pre-filing negotiations are very common, and it is not unusual for the Antitrust Division to inquire of the prospective defendants whether they wish to pre-file in all cases, other Antitrust Division officials told the committee staff that they viewed pre-filing negotiations to be appropriate only when the defendants have agreed in principle to the terms of the relief sought by the government in its complaint. Although it apparently was not unusual for Mitchell to send notes to McLaren on a variety of subjects, and that at the time McLaren did not consider his written communication unusual or significant, Mitchell's written directive to McLaren must be viewed in the light of Mitchell's participation at that time, described in 6b below, to raise $1 million or more in campaign contributions for AMPI. Nonetheless, the division carried out Mitchell's order, until it became clear that after all, the AMPI case was an inappropriate one for pre-filing negotiations. 3. Pre-filing negotiations and the filing of the suit. On Monday, January 24, 1972, Sarbaugh contacted Stuart Russell, one of the counsel for AMPI, and informed him that the Chicago office had been authorized to file an antitrust complaint against AMPI and to ask AMPI if it wanted to engage in pre-filing negotiations, which might lead to a consent decree. Sarbaugh gave Russell until Thursday, January 27th, to respond, And in keeping with division practice, he stated that the government would permit the negotiations to continue for a period of time not to exceed 60 days. Otherwise, the complaint would be filed Friday, January 28, 1972. In response, Russell told Sarbaugh that AMPI would probably want to negotiate, and that he would contact AMPI's Chicago counsel, Martin Burns, who would most likely contact the Chicago office to see the complaint. On Tuesday, January 25, 1972, Burns read the complaint, and on January 26th, he called to say that AMPI wanted to engage in pre-filing negotiations. On January 27, 1972, at a meeting with the staff at the Chicago office, Burns and his partner, Erwin Henninger, confirmed AMPI's intention to engage in pre-filing negotiations. However, it soon became clear that AMPI was not prepared to agree in principle to the relief requested by the government, the threshold requirement for the negotiations to continue. For example, according to Sarbaugh, Henninger questioned the propriety of the civil antitrust complaint and stated his belief that a number of AMPI's alleged activities were exempt under the Capper-Volstead Act. There also seemed to be another component to AMPI's tactics in the negotiations. At that point in late January, McLaren was scheduled to leave his post for a federal judgeship in less than a week. The 60-day pre-filing negotiations, if completed, would extend well beyond the time of his departure. Sarbaugh says that at the January 27th meeting, Henninger mentioned that with McLaren leaving the department, the complaint would probably have to be signed by his successor before it could be filed. Henninger also referred to the fact that dairymen were big political contributors. Sarbaugh, who had known Henninger professionally for a number of years, was shocked and concerned by the reference to political contributions. He thought this was the most blunt and tactless comment he had ever heard Henninger make. Its meaning was clear, at least to Sarbaugh and McLaren. By stalling beyond the time of McLaren's departure, AMPI might be able to use the pre-filing negotiation period to block politically the filing of the suit. Although the meeting ended with the understanding that negotiations would continue, Sarbaugh made it clear to Henninger that the government was not committed to pre-filing negotiations for the full 60-day period, and that the complaint would be filed if, at any time, the parties reached an impasse in the negotiations. Sarbaugh was concerned about Henninger's attitude toward the negotiations. He felt that there had been no real agreement by Henninger that AMPI would accept the relief sought in the complaint. He was aware that dairy cooperatives had been big contributors, and in light of Henninger's comments, he brought the matter to the attention of Assistant Attorney General McLaren, who instructed him to call Henninger and tell him that the Chicago office would give him a proposed consent decree by the close of business on Friday, January 28th. McLaren said that unless AMPI consented to the basic terms of the proposed decree by the close of business on Monday, January 31st, the suit would be filed the next day, February 1st. Sarbaugh relayed the message to Henninger and told him that the AMPI case was not an appropriate case for pre-filing negotiations, since AMPI had not requested the negotiations in the first place, and that AMPI had not agreed in principle to the relief requested. The proposed final judgment was submitted to Henninger at 3:30 on Friday afternoon, along with a letter requesting that AMPI make a written response before the close of business on Monday, January 31st. On Monday afternoon, Henninger called Sarbaugh and told him that AMPI could not meet the suggested deadline of the Antitrust Division, since it could not resolve all of the problems raised by the proposed judgment before the close of business that day. The antitrust suit was filed February 1, 1972, McLaren's last day in office at the Justice Department. B. White House involvement prior to the filing of the suit. McLaren's original recommendation for a grand jury in the AMPI case went to Mitchell on the very same date, September 10, 1971, that the milk producers were contributing the last $62,500 of the $232,500 to the multiple presidential campaign committees. During the next 2 months, while Mitchell was considering what action to take, White House aides began monitoring the antitrust investigation, and there is evidence that Mitchell conferred with Haldeman about the milk producer contributions and the antitrust problems before he turned down McLaren's recommendation for a grand jury investigation. There is also evidence that in January 1972, Mitchell was taking an active role in further solicitations of the milk producers, at the very time he directed McLaren to enter in pre-filing negotiations with AMPI. 1. Monitoring of the antitrust investigation by White House aides. Although a resolution of antitrust problems was not on the original list of milk producer objectives outlined to Kalmbach in 1969, it was a subject of discussion between them and the White House in 1970 and 1971. Jack Gleason says he remembers meeting with Nelson and Parr in early 1970 and discussing their concern over possible trouble from the Justice Department. Henry Cashin, one of Colson's assistants, told the committee staff that sometime in 1971 or 1972, MaryAnn Harrison told him that the dairy people were going to get clobbered by the antitrust division. Cashin says that since Justice Department matters were the responsibility in the White House of John Dean, he may have passed on the information to Dean, and because of Colson's interest in the milk producers, to Colson too. On September 24, 1971, 3 weeks after the president spoke to the AMPI convention and 2 weeks after the $62,500 contribution was made and McLaren's recommendation went to Mitchell, Colson sent a memo to Haldeman, Eyes Only, entitled Milk Producers, with the following information on the antitrust investigation. There is underway in the Justice Department at this moment an antitrust division investigation of the milk producer cooperatives. Attached is the 1956 court decision exempting the milk producers from applications of the antitrust laws. If this goes too far, there will be a number of very serious adverse consequences, which I would be glad to elaborate on in detail. Haldeman says that he does not know what serious adverse consequences Colson meant and does not remember any White House concern about the antitrust investigation, despite the continued interest evidenced by the president and his staff over milk producer support for the president's re-election effort, and despite the negative impact that criminal prosecution of the co-op and its leaders would be expected to have on that support. Haldeman apparently did want at least some further information on the matter, because on October 6th, Dean sent to Haldeman aide Gordon Strachan the information you requested, a report on a possible antitrust exemption for AMPI and the current activities within the Department of Justice concerning AMPI. At that point, the current activities included the recommendation for a grand jury investigation, which was awaiting Mitchell's approval. In his September 24th memo to Haldeman, Colson indicated that he wanted to stay out of it, and he suggested that the antitrust investigation should be taken up at one of your meetings. Haldeman apparently discussed the matter with Mitchell at a subsequent political matters meeting. 2. Haldeman-Mitchell meeting. There is evidence that Mitchell was deeply involved in the president's campaign long before he resigned as Attorney General, and that he regularly met with Haldeman, presidential assistant and later deputy campaign director for CRP, Jeb Stuart Magruder, and others to pass on campaign matters. One political matter scheduled for discussion at such a meeting was the antitrust investigation of the milk producers. On November 4, 1971, 6 days after McLaren's second memorandum to Mitchell repeating his recommendation for a grand jury investigation, a political matters meeting was held, attended by Haldeman and Mitchell, and for a part of the meeting, Magruder and Strachan. In preparation for the meeting, Strachan prepared an agenda of subjects to be discussed and a talking paper briefly detailing each subject. The agenda was distributed to all 4 attendees, but the talking paper was distributed to only Haldeman and Mitchell and not Magruder. Item 15 of the paper indicates that the department's antitrust investigation of the milk producers was to be discussed as well as milk money. 15. As you probably know, the milk producers currently enjoy an antitrust exemption resulting from a 1956 decision by the Federal District for the District of Columbia. A report here at the White House indicates the Antitrust Division at Justice is now investigating that exemption. Another report indicates that the Washington Post has assigned 4 reporters full-time on the Milk Money Project. Do I understand correctly that you have directed John Dean to review any reports that have to be filed on the Hill connected with the receipt of the milk money? Neither Haldeman nor Mitchell remembers any discussion at that meeting of the antitrust matter. Mitchell does not even remember knowing that the milk producers who were the subject of the investigation were the milk producers who were making campaign contributions. There seems little doubt, however, that the subject was taken up. Strachan has testified that matters not covered in one meeting were taken up at the next, and the White House has not disclosed any agenda or talking paper for a subsequent political matters meeting in which the matter is listed. Although Mitchell denies it, the talking paper clearly suggests that the Attorney General was informed of the connection between the milk producers under investigation and milk money, and that Haldeman and the Attorney General discussed the investigation in the context of the campaign and milk producer contributions. The day before his meeting with Mitchell, November 3rd, and again on November 29th, the day before Mitchell's rejection of the request for a grand jury, Haldeman met with Choitner, who was counsel to the milk producers. Haldeman does not remember discussing the antitrust suit with Choitner at either of these meetings. 3. Other Mitchell contacts. Mitchell also met with Kalmbach several times during the September 10th to November 30th time period while the McLaren recommendation lay on his desk. Although he does not specifically recall speaking to him, Mitchell said in a staff interview that the only person other than Kalmbach with whom he may have discussed the antitrust suit was Choitner. On November 18th, according to Mitchell's logs, he had a series of afternoon meetings or conversations with Kalmbach and others who were familiar with the milk producers, although there is no evidence of what was discussed in those contacts. At 2:10, he met with Dean and Kalmbach. At 3:15, Harry Dent called him, and at 4:30, Haldeman called him. It appears that Mitchell then met with the president, because according to John Connolly's logs, Connolly received a call at 4:58 p.m. from Mitchell in the president's office. 12 days later, Mitchell rejected McLaren's request for a grand jury investigation. In early 1972, when McLaren went back to Mitchell for his approval of the civil complaint against AMPI, Mitchell was again making campaign decisions concerning AMPI. As discussed in the following section, Kalmbach met with AMPI officials in January and February of 1972 to make arrangements for the remaining contribution toward their campaign commitment. On January 13, 1972, the day before one such meeting, Kalmbach conferred with Mitchell, who is reported to have been informed and to have approved of the continued Kalmbach AMPI contacts to seek ways for the co-ops to fulfill their $2 million commitment. On January 21st at 2:30, Mitchell met with Kalmbach on the subject of campaign contributions. At that meeting, Kalmbach reported to him that he had met with the milk producers who had confirmed that the milk money will continue to come in. The next day, Mitchell approved the civil suit, but directed McLaren to begin pre-filing negotiations. McLaren has stated that he caused the AMPI suit to be filed on February 1st before he left the department because he felt that AMPI was not engaging in the negotiations in good faith and that he wanted to preclude any possible attempt by AMPI to resist the filing of the suit by some political means. In view of the White House involvement, Henninger's reference during the pre-filing negotiations to political contributions and Mitchell's previous decision in the case favorable to the milk producers, there was a basis for McLaren's concern over the progress of the negotiations and the ultimate filing of the suit. There is also evidence that in the months that followed, AMPI officials offered more substantial contributions to gain a favorable resolution of the suit. End of Section 33. Recording by Paul Waldrop of Waynesville, North Carolina.
Section 34 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. C. Fundraising meetings between AMPI and Kalmbach in January and February 1972. The Bennett committees were closed after the adverse publicity over the 1971 milk producer contributions, but there was still a large amount to be contributed by the milk producers to honor their commitment to the president's campaign, and Nelson wanted to honor that commitment. Instead of working through Harrison and Chotiner, as he had done the previous year, Jacobson was asked to contact Kalmbach and work out a different set of arrangements, and as a result, several meetings were held between AMPI officials and Kalmbach in January and February. Footnote: Nelson apparently felt that Harrison had been ineffective in arranging for the 1971 contributions. End footnote. In the meantime, on January 12, 1972, Nelson was replaced as general manager of AMPI by George MaryAnn, and 2 weeks later, the antitrust suit was filed by the Justice Department against AMPI. 1. Kalmbach-Nelson-Jacobson meeting on January 14. Kalmbach was generally uninvolved in the milk producer contributions from the summer of 1971 until the end of the year. At that point, Jacobson contacted him, explained that he was a partner of Milton Seymour, who had delivered the $100,000 to Kalmbach 2 years before, and told him the milk producers wanted to meet with him again. A meeting was then arranged for Kalmbach, Jacobson, and Nelson for January 14, 1972, in California. Before the meeting, a major change was made in AMPI's top management. On January 12, the AMPI board voted to remove Nelson as general manager and elected George MaryAnn, a former Assistant Secretary of Agriculture in the Johnson administration, and from 1968 until 1972, a consultant and then director of programming of AMPI. Nelson was given a 7-year consulting contract renewable annually at $100,000 per year, and over the next few weeks, Parr and several other AMPI officials and employees left AMPI. Within hours after his removal, Nelson went to MaryAnn to ask permission to use the AMPI corporate jet for his trip to California to meet with Kalmbach on the 14th. Nelson says that he told MaryAnn of the scheduled meeting, and MaryAnn instructed him to follow through with it. Jacobson testified that before the meeting, Nelson told him that MaryAnn had authorized him to meet with Kalmbach. MaryAnn denies being told of the meeting, but acknowledges that he gave Nelson permission to use the jet, quote, to clean up odds and ends, end quote. On January 13, Nelson and Jacobson flew to California. When they met with Kalmbach the next morning, they told him that they wanted to continue the contributions in 1972 with as much money as possible, but hopefully without the type of publicity of the previous year. Footnote: although there is no record of the flight in the AMPI jet log, the committee has obtained records of hotel charges for Nelson and the pilots in the Los Angeles area for the night of the 13th, and of airport charges to AMPI for an airplane on the 14th. End footnote. They indicated that since Nelson had been replaced, MaryAnn would have to be consulted before any final decisions were made. It is evident that both Haldeman and Mitchell were monitoring these contacts between Kalmbach and the milk producers. As mentioned above, Kalmbach had met with Mitchell on the 13th, the day before the meeting with Jacobson and Nelson. Kalmbach says that since Jacobson was a partner of Seymour, who had been active in the Muskie campaign, Kalmbach checked with Mitchell, who approved of him meeting with Jacobson and the milk producers to arrange for further contributions. Kalmbach also reported the results of the January 14 meeting to Strachan, who relayed the report to Haldeman in a, quote, political matters, end quote, memo on January 18. 1. Herb Kalmbach met with Messrs. Jacobson and Nelson on January the 14th concerning the milk money. Kalmbach had a, quote, good meeting. The money will continue to come in, but the milk people do not want to continue to deal with Reeves and Harrison, Chotner's firm. Kalmbach would take over this project as a special assignment. He will ask the Attorney General on January the 20th. The Attorney General approved of Kalmbach meeting with Jacobson, even though Milt Seymour is Jacobson's law partner and treasurer of the Muskie campaign. Kalmbach informed Colson of the meeting, but would not tell Colson who asked him to see Jacobson. Kalmbach believes someone should give all information about the milk situation to Colson. I told him Colson was no longer involved. Recommendation: that you inform Colson of the milk situation, and that Kalmbach be asked not to discuss the milk situation with Colson in the future. Footnote: this document was requested by the committee, but the president refused to provide it. An excised portion of the document was made public in connection with the Nader v. Butts case. End footnote. As related by Kalmbach, there was a great antipathy between Colson and both Mitchell and Seymour. Because of Mitchell's and Jacobson's involvement, Strachan recommended to Haldeman that Colson not be informed of all aspects of the continuing solicitations of the dairymen. Footnote: Mitchell once called Colson, quote, a walking time bomb, end quote, end footnote. Haldeman approved Strachan's recommendation and wrote at the top of the memorandum, quote, good job, end quote. According to Mitchell's logs, he next met with Kalmbach on January 21, when Kalmbach reported the results of the meeting to Mitchell. As noted above, this briefing took place the day before Mitchell approved the institution of a civil antitrust suit against AMPI while directing McLaren to delay the filing and begin pre-filing negotiations. 2. Kalmbach-AMPI meeting on February 3. By the time the next meeting in 1972 between Kalmbach and AMPI leaders occurred on February 3, 3 developments had taken place that would have an impact in subsequent meetings with Kalmbach. First, the Justice Department antitrust suit against AMPI, described above, had been filed on February 1. Second, a lawsuit had been filed by Ralph Nader and several public interest groups against the Secretary of Agriculture, alleging that the 1971 price support increase was illegal. Third, George MaryAnn had become involved in AMPI's political affairs. A. Nader v. Butts. On January 24, 1972, a suit was filed in the Federal District Court in the District of Columbia by Ralph Nader, Public Citizen, Incorporated, Federation of Homemakers and Consumers Association of the District of Columbia, against Secretary of Agriculture Butts, who had replaced Secretary Hardin in November 1971, and the Commodity Credit Corporation, alleging that the 1971 milk price support increase was not based on statutory grounds, but on political considerations, including contributions. The complaint further alleged that the increase was, quote, unlawful and unenforceable, end quote, and sought a declaratory judgment and an injunction against continuing support at the $4.93 level. There was immediate reaction to the suit in the White House. On February 1, Dean sent a memorandum to Ehrlichman describing the suit and its background. Although he thought the suit could be defeated, he warned that, quote, the discovery proceedings could prove disastrous, end quote. In particular, he pointed out that dairy industry officials, quote, will certainly be questioned in detail, end quote, about, quote, all commitments made by the president, end quote, at the March 23, 1971 meeting, and that in the course of their depositions, quote, questioning about their duties with the committees and the manner in which the committees operate could prove highly embarrassing in an election year, end quote. Footnote. Also on February 1, Dean sent another memo to Ehrlichman notifying him that the antitrust suit had been filed against AMPI, quote, the largest of the 3 cooperatives involved in the Nader case and the organizer of TAPE, end quote. End footnote. That same day, February 1, Strachan sent a, quote, political matters, unquote, memo to Haldeman, in which he described Kalmbach's apparent concern about the Nader suit. Kalmbach is very concerned about his involvement in the milk producers' situation. Kalmbach will accept the risk of being subpoenaed by the court in connection with the Nader milk suit. The Attorney General believes Kalmbach should continue to handle the milk project, but Kalmbach wants your advice. Recommendation that Kalmbach not be involved in the milk project because of the risk of disclosure. Footnote. This document, along with a number of other White House documents referring to milk producer contributions, were denied by the President to the Select Committee. Some, but not all, of the documents, including an excised portion of the above-described memo, were subsequently made public in the Nader v. Butts suit. In referring to White House communications to him from Colson, Strachan, and perhaps Dean on dairy money, commitments, the antitrust and Nader suits, and related matters, Haldeman observed that they, quote, tended to over-dramatize a lot of things and to lay more import on the language than they really needed, end quote. Haldeman tried to discount the, quote, colorful language, unquote, as he put it, of these White House memos and explained that, quote, these were written as internal office memorandums, not as public documents, end quote. End footnote. Haldeman wrote on the memo, quote, I'll discuss with AG, end quote. Based on his notes written on the memo, Strachan says he relayed this comment to Kalmbach on the 3rd, the day of Kalmbach's next meeting with the AMPI people, and included this item in a talking paper he prepared for a Haldeman-Mitchell meeting on February 9. Footnote. The White House has omitted any reference to this alleged talking paper from its list of relevant milk documents. End footnote. As discussed below, White House plans to proceed with the milk producer contributions and Kalmbach's involvement were not changed until March, when the ITT scandal broke and it appeared to Kalmbach that the AMPI case, too, might involve a quid pro quo. B. George MaryAnn and the question of previous commitments of contributions. Although George MaryAnn had assisted Nelson in the dairy efforts to secure a price support increase in March 1971, he claims that when he succeeded to Nelson's position in January 1972, he did not know of any commitments for contributions to the president's campaign. MaryAnn explained that with the publicity in late 1971 over the price decision and dairy contributions, and with widespread rumors among AMPI members of commitments, when he assumed office, he did ask AMPI's former officials what political commitments were outstanding, but that no one told him any commitments existed, perhaps because they felt he would not have honored them. For example, MaryAnn had heard from AMPI employee Byford Bain that Parr had made a commitment to the president's campaign of $2.6 million. MaryAnn says that in the presence of John Butterbrodt, the AMPI board president, he asked Parr in early 1972 whether such a commitment existed. According to MaryAnn, Parr told him, quote, that no commitment had been made, and he further said that he was not acquainted with Mr. Colson. End quote. MaryAnn says he also asked Nelson and Jacobson, who he says denied knowledge of any commitments, but who advised MaryAnn to make further contributions by telling him, quote, we have to live with those people for another 4 years. End quote. Both Jacobson and Parr dispute MaryAnn and say that he never even asked them about a commitment, although Jacobson says he recommended on his own to MaryAnn that they make a substantial contribution. Moreover, there is evidence that MaryAnn knew of a commitment and reluctantly had decided to honor it. Nelson testified that there had been a commitment, which in January 1972 he felt had not yet been satisfied, and he says he told this to MaryAnn. In fact, Robert O. Isham, the tape trustee and AMPI comptroller, whom MaryAnn was consulting, says that in the first several months of 1972, MaryAnn indicated to him that he felt he was going to have to honor their commitments and contribute to the president's campaign. Indeed, Isham says he resigned from TAPE just prior to April 7 in order to avoid involvement in any such contributions. There is evidence that after MaryAnn was informed of the facts sometime between January 14 and the February 3 meeting with Kalmbach, the original $2 million commitment was scaled down to $1 million. In his February 1st memo to Haldeman, Strachan reported on Kalmbach's progress in raising funds from the milk people, including Kalmbach's belief that, quote, Jacobson and Nelson will deliver, though they have cut the original 2,000 commitment back to 1,000, end quote. Nelson testified that he reaffirmed at the January 14 meeting the original $2 million commitment, and as of January 18, Kalmbach had reported to Strachan no change in that commitment. Although he could not pinpoint the date, Kalmbach presumably was informed of the change between January 18 and February 1, during the period when Nelson and Jacobson were in touch with MaryAnn and then Kalmbach to arrange the next meeting between AMPI and Kalmbach. This evidence and that of the February 3 meeting and events thereafter indicate that MaryAnn, a lifelong Democrat and an official in the Johnson administration with no particular sympathy for the president's re-election effort, felt obligated under the prior commitment and was indeed prepared to meet that obligation, although in the context of AMPI's most recent problem, the antitrust suit. Footnote. In his testimony before the Select Committee, MaryAnn stated that with regard to the 1972 election, quote, I would have had no great personal trauma if the Republicans would have lost in the Middle West, end quote. End footnote. C. February 3 meeting. On February 3, MaryAnn, Nelson, and Jacobson flew to California and met with Kalmbach and two of his law partners, Frank DeMarco, one of the president's tax attorneys and counsel to the California FCRP, and Robert Olson, now a California Superior Court judge. Although DeMarco, who had not previously met the milk producer representatives, does not remember any discussion of contributions, the others present agree that the making of substantial contributions by the dairy co-op was discussed. Footnote. In fact, Olson says some of the discussion of pre-April 7 contributions and committees took place with DeMarco present in DeMarco's office, and that Kalmbach perhaps wanted Olson and DeMarco present as witnesses. End footnote. After Kalmbach told MaryAnn that it was to be understood that there was no quid pro quo involved, Kalmbach told them that he understood they were interested in making a substantial contribution. According to MaryAnn, the discussion centered on a contribution of $750,000, and either Kalmbach or DeMarco suggested that most of the money, $700,000, could be contributed prior to April 7 and the rest later. Footnote. Jacobson says the pre-April 7 contribution was to be made in several installments, such as 1/3, 1/3, and 1/4 of the total $750,000 contribution. End footnote. It was indicated that, as opposed to the previous year, the pre-April 7 money would go to real committees with real officers in a number of states, but independent of the state Republican committees. MaryAnn says that the purpose of the procedure, as he understood it, was to avoid public disclosure of more milk producer contributions to the president's campaign. Although MaryAnn claims he objected to the suggested procedure, there is evidence that, as a result of the meeting and further contact with the AMPI people, Kalmbach fully expected substantially all the $750,000 to come in prior to April 7 to fulfill the amended $1 million commitment. Footnote. John Butterbrodt, AMPI's president, testified that MaryAnn subsequently told him that Kalmbach suggested the contributions be made to state committees and that the ultimate source, the president's campaign, would not be disclosed and would remain secret. He says that he and MaryAnn rejected that alternative. End footnote. In a February 16 Political Matters memo from Strachan to Haldeman, it was reported that, quote, Kalmbach is working with the milk people to increase the 233 currently banked to 1,000 by April 7. Footnote. Kalmbach says he was working out the details of the transaction with Jacobson after the February 3 meeting. End footnote. At the same meeting on February 3 that there was a discussion of contributions, there was also a discussion of a substantive problem. According to Jacobson, and as more fully discussed in Section 6E below, MaryAnn complained to Kalmbach about the Justice Department antitrust suit against AMPI, which had been filed 2 days earlier. This was preliminary to further discussions in March and early April, which, it is alleged, resulted in an effort to link further contributions to a favorable resolution of the suit. End of Section 34. Recording by Linda Johnson. Section 35 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. D. Milk producer meetings on March 16 with Kalmbach and Connolly. In March 1972, the AMPI officials came to Washington and met with Kalmbach and then-Secretary Connolly. By then, the milk producers were expressing their deep concern over the antitrust suit, and in light of the emerging ITT scandal, the Republicans apparently were developing a new strategy to avoid further embarrassment from milk producer contributions by postponing them until just prior to the election. 1. Meeting with Kalmbach. By mid-March, MaryAnn was, quote, beginning to get nervous, end quote, about a commitment because of the, quote, remarkable temporal association of contributions, end quote, and the price support effort in 1971. As noted above, Isham understood from MaryAnn that TAPE would contribute, and this is corroborated by Nelson, who says that MaryAnn, in fact, had decided after February 3, but before the next meeting with Kalmbach, to contribute more money to the president's campaign. But by that time, damaging information had been publicized linking the settlement of a government antitrust suit against ITT and a large contribution by ITT through its subsidiaries for the Republican National Convention, following high-level meetings between Mitchell and ITT officials. Kalmbach says that he anticipated an effort by AMPI to seek a quid pro quo on the antitrust suit, and that he decided to tell the AMPI officials that he would not solicit any more contributions from them, and that any pledge for contributions would be abrogated. On March 16, MaryAnn, Nelson, and Jacobson met with Kalmbach in his room in the Madison Hotel. Footnote: the committee has fixed the date of the meeting based upon evidence it has uncovered in its investigation. MaryAnn and Jacobson testified that they were not sure of the date of the meeting, although they thought it probably occurred sometime in March or April. Although MaryAnn said he thought the meeting occurred on April 23 or 24, Kalmbach was not in Washington in April after the 7th. Nelson testified that the meeting took place on the same day they met with Secretary Connally, which, according to Connally's logs, was March 16. Kalmbach testified that he, too, thought the meeting occurred in mid-March. The committee staff has reviewed the logs and hotel charges of those present at the meeting and found that the only time in March or April 1972 when all four were at the Madison Hotel in Washington was on March 15 and 16. Moreover, Jacobson added that Kalmbach was about to leave for New York at the time of the meeting, and Kalmbach's logs indicated that he left Washington and went to New York on March 16. Therefore, it appears that the meeting took place on the day of the 16th. End footnote. The meeting was brief. Kalmbach told them of his decision, and MaryAnn replied that it should be clearly understood that he, MaryAnn, was not breaching any commitments. It is not clear whether, as a result of the meeting, all further solicitations for the president's campaign were terminated, or just whether Kalmbach personally was withdrawing, and that solicitations were being suspended only for a time. Although MaryAnn says that it was his understanding that no further solicitations would be made by anyone connected with the campaign effort, Kalmbach's message was, according to MaryAnn's own recollection, more limited. Kalmbach told him that, quote, I will not proceed any further with discussions or negotiations on political contributions, end quote, and that he, quote, personally would make no more representation to AMPI, end quote. Nelson says that Kalmbach told them he was not going to seek additional contributions, quote, presently, and that Nelson understood that there would be further solicitations after April 7. Subsequent events have corroborated Nelson's understanding. It appears that the efforts to obtain further milk producers' support for the president were not terminated on March 16, but only postponed until just prior to the election. In fact, after meeting with Kalmbach on the 16th, the milk producers met with Secretary Connally, who in a similar fashion advised them only to postpone their contributions. 2. Meeting with Connally. The milk producers had secured the assistance of Treasury Secretary Connally in March 1971 in their successful effort to obtain a price support increase. A year later, in March 1972, they again turned to him for help in the antitrust suit and several other matters. It is virtually undisputed that they met with Connolly on March 16 and discussed their antitrust, IRS, and other problems, that Connolly called Mitchell about the impact of these problems on the president's campaign, and that there was a reference at the meeting to postponing contributions until later in the year. Lilly testified that upon MaryAnn's return to San Antonio, MaryAnn told him that it was also understood that the antitrust suit and a pending IRS investigation of MPI would be slowed and ultimately terminated on favorable terms for AMPI. Before turning to the March 16, 1972 meeting itself, a discussion of the background of the IRS investigation and related matters, including a possible criminal prosecution against AMPI by the Justice Department for a corporate political contribution, is set forth below. A. IRS and Justice Department investigations. In the course of a routine audit by IRS of the income tax return of AMPI's predecessor MPI for the 1968 fiscal year, IRS agents uncovered payments in 1968 by MPI and several of its constituent co-ops totaling over $90,000 from corporate funds to a Washington, D.C. printing firm ostensibly for the costs of printing a compilation of President Johnson's messages to the 90th Congress titled, quote, "No Retreat from Tomorrow," end quote. Footnote. In addition to the amounts paid to the printing firm, approximately $14,000 more was also paid by AMPI to two other firms for expenses relating to publication of the book. End footnote. Upon further investigation, it was found that earlier in 1968, the printer had billed and received payment from the Salute to the President Committee, an adjunct of the DNC, and that the subsequent 3 co-op checks to that firm for the $90,000 solicited by an official of the DNC constituted a duplicate payment and were therefore endorsed by the printer to the Salute to the President Committee. The co-op reflected these payments on its corporate books partly as an, quote, advertising expense and partly as, quote, office supplies expense. Footnote. In fact, the book, quote, "No Retreat from Tomorrow," end quote, bears no indication that it was paid for or sponsored by AMPI, and thus appears to have been of no advertising or public relations benefit to the co-op. End footnote. The San Antonio IRS agent in charge of the audit, Doyle Bond, notified AMPI in mid-1971 that this transaction was being investigated. Bob Lilly immediately informed Jake Jacobson by letter dated August 26, 1971, of the matter, and concluded, quote, "This should, and did, raise eyebrows," end quote. Jacobson says that in 1972, after discussing the tax matter with either MaryAnn or Nelson, he suggested that AMPI retain Marvin Colley, whom he considered, quote, "the best tax lawyer in Texas," end quote, and who was a partner of Vinson, Elkins, Searles, Connolly, and Smith, Treasury Secretary Connolly's former law firm. Connolly and Jacobson each testified that before AMPI hired Colley, Jacobson asked Connolly whether he would have any objection. Connolly told Jacobson he did not. Connolly and Jacobson testified that their discussion took place sometime in 1972, possibly at the close of the March 16 meeting with MaryAnn. However, since AMPI records indicate that Colley was retained by AMPI in January or early February 1972, and the Jacobson-Connolly discussion took place preliminary to AMPI hiring Colley, the conversation must have taken place prior to that meeting. At about the same time that Colley was being retained, IRS Commissioner Johnny Walters was contacted concerning the matter, and personally inquired about it from the IRS Regional Commissioner from the Southwest region with jurisdiction over the MPI audit, Albert Brisbin. During January 17 to 19, 1972, Brisbin and Walters attended a meeting for regional commissioners in Washington. At that time, according to Brisbin, Commissioner Walters handed him a 3-paragraph document apparently prepared by a co-op representative, stating the facts with respect to the tax matter under investigation, and he asked Brisbin to give him a report. Brisbin says he understood that the document had been given to Walters by some high official at the Treasury Department, presumably Connolly or one of his assistant secretaries. Upon returning to Dallas, Brisbin passed the matter and the document on to the then IRS District Director for Austin, Robert Finney, who in turn sent it to his subordinate with the handwritten comment, quote, "Al Brisbin quoted Commissioner Walters to me saying, 'Do what's right, but let's close it as soon as we can.'" End quote. Brisbin recalls Walters giving him those instructions at the time he gave him the document in Washington, and he and Finney agree that Brisbin called Finney personally to pass on Walters' comment. Finney considered this a very unusual aspect of the case and said that he did not recall any similar request from Walters. When asked about the incident, Walters said he had no recollection of handling the document, and he is fairly certain that he did not receive it from Connolly or any top Treasury official. Although he knows Colley, Walters is sure Colley did not speak to him about the case. Walters has some recollection of having heard the title of the book and of telling an IRS official to complete the audit and not let the matter drag on. As a result of Walters' inquiry, a meeting was held in Brisbin's office on February 1, 1972, at which Agent Bond briefed the regional officials, including Brisbin. By that time, Bond had recommended that the matter be referred to the Criminal Division of the Justice Department as a possible violation of Title 18, Section 610, Corporate Political Contributions. At the meeting, 3 decisions were made. The taxpayer, AMPI, was to be given an additional opportunity to justify the expenditures to IRS before IRS disallowed them. The matter would be referred to the Criminal Division for possible criminal prosecution, and a sensitive case report would be prepared for the commissioner. The report was prepared and hand-delivered by Brisbin to Walters a week later, when Walters was in Texas on unrelated matters, and on February 15, the report was forwarded to Washington. Walters had no recollection of the briefing or the report. With respect to the referral for criminal prosecution, Brisbin said that his district director Finney still objected to the referral after the February 1 meeting. Normally, the district director would sign the referral and the regional commissioner would not review it. However, because of Finney's objections, Brisbin says that in an unusual move, he overruled Finney and took the matter from him, and on February 22, 1972, personally signed the memorandum for referral of the matter to the Justice Department. Footnote: Brisbin's memo was forwarded to the Intelligence Division of IRS, according to regular IRS procedure, and then forwarded to Henry Peterson, Assistant Attorney General, on February 29, 1972. End footnote. Even more unusual was the reason Brisbin says Finney gave for his objection. According to Brisbin, Finney didn't object on substantive grounds. Rather, Finney expressed concern to Brisbin that if the matter were referred to the Justice Department, quote, "it will be written up in Jack Anderson," end quote. Finney, who was interviewed before Brisbin, made no mention in a staff interview of any objection on his part to the referral. Brisbin says he understood Finney to be concerned about possible embarrassment to the former president and those close to him, including Connolly. Finney had known President Johnson and Connally for over 25 years and had joined with Connally and several others in 1946 in investing in a local radio station in Texas. Finney says that he had no contact with Connally concerning the audit, but acknowledged that Colley, whom Finney also knew, did speak to him once about the matter. According to Finney, Colley told him that he had been retained by AMPI and he was advising his client not to oppose the IRS disallowance of the expense deduction for the book. Finney says that he told Colley of the referral to the Justice Department. Although Finney recalls Colley meeting with him in Finney's office, Colley's billings to AMPI show only one contact with Finney, a long-distance telephone call on March 8, 1972. Colley had been interviewed by the staff prior to the Finney interview. When questioned about his conversation with Finney, he testified. Question: What did Mr. Finney tell you? What was the total of his conversation? Answer: I told Mr. Finney that I had advised AMPI to give up entirely on the assertions by the Internal Revenue Service, and that I hoped that that would close the case. I further said that the case involved people of wide public fame, and that I certainly hoped that there wouldn't be leaks and he would take appropriate action to make sure that the normal secrecy of the Internal Revenue Service was asserted. Question: What did Mr. Finney have to say? Answer: He thanked me for the information. He said he assumed that the usual secrecy would be preserved, but he was familiar with the case and that, well, that was about all. Colley made no reference to the matter of the referral to the Justice Department Finney says was discussed. During the following week, March 13 to 17, the revenue agent, Bond, met with AMPI representatives who informed him that AMPI would not contest disqualification of the expense deduction in question. On March 15, 1972, Bond recommended to his superior that he be permitted to audit the returns for the subsequent 2 years, the final 2 returns filed by MPI, for the periods ending June 30, 1969 and September 30, 1969, and the first AMPI return for the period ending June 30, 1970. In his recommendation, Bond stated that, quote, at least one more examination should be conducted before we can really evaluate the audit potential of the organization, end quote. In contrast to the time spent on the 1968 audit, according to IRS records, approximately 1,700 hours, he noted that, quote, future examinations can be conducted in considerably less time, end quote. Within the next few days, AMPI notified IRS that it would not contest the IRS disallowance of the expense deductions for the book, and the 1968 audit was closed. At that point, after the referral to the Justice Department and Bond's recommendation for additional tax audits, MaryAnn, Nelson, and Jacobson met with Connally. B. The meeting. Jacobson says that he wanted to introduce MaryAnn to Connally, whom he considered to be influential in the administration. MaryAnn says Jacobson told him, quote, Mr. Connally has become a very important man in this administration. He is going to be an important man in the future. End quote. Jacobson thought the first meeting would be purely introductory, and that he did not expect MaryAnn to take up with Connally any problems until a later time. Instead, MaryAnn took the opportunity, quote, as a forum for discussing all the problems that AMPI had been having with this administration, end quote, including, quote, the antitrust suit and dairy imports and price supports, end quote. MaryAnn says he told Connally that the antitrust litigation was costing AMPI a great deal of money, and that, together with actions in other areas, evidenced, quote, a pattern of adverse reaction on the part of the administration, end quote. Both MaryAnn and Jacobson conceded that the antitrust matter was discussed, with the hope that Connolly would perhaps talk to others to help them in the ongoing settlement negotiations, and Jacobson says that Connolly was, quote, sympathetic, end quote. Connolly says the antitrust suit and other problems were reviewed as, quote, an informative type of thing, end quote, and he does not recall that they asked him to do anything for them. Connolly responded to AMPI's request immediately and apparently at a purely political level. Connolly says that he called Mitchell that day or the next day to relay to him the information that the antitrust suit was going to have a, quote, very damaging effect politically upon the Republican Party, end quote. Footnote: Connolly's logs indicate a call to Mitchell on the day of the meeting, March 16, but no record was kept of the time of his telephone calls except for those to and from the president. End footnote. By MaryAnn's account, Connolly telephoned Mitchell during the meeting in the presence of MaryAnn, Nelson, and Jacobson, despite the fact that Connolly considered this, quote, unusual. MaryAnn says Connolly told Mitchell that, I have a group of people here who seem to be somewhat incensed with what they seem to consider systematic punitive action of this administration. This can do us damage in the Middle West. You get some people out there and find out what is going on, because we're going to have political trouble if we don't. Footnote: Mitchell said that he could not remember any call from Connolly about the milk producers' antitrust suit. End footnote. MaryAnn says Connolly also called Senator Dole, then chairman of the Republican National Committee, and gave him essentially the same information. It appears that, in addition to these references to the political aspects of the antitrust suit, there was a reference to political contributions in the meeting, according to MaryAnn, at Connolly's initiation. MaryAnn testified that at the end of the meeting, Connolly remarked that political contributions, quote, would be more useful toward the end of the campaign than now. They'll need it worse at the end of the campaign than they do now, end quote. When Connolly was asked in an executive session before the Select Committee on November 15, 1973, whether there was any discussion of the timing of political contributions by the milk producers, Connolly testified that he did not recall any discussion of contributions. After MaryAnn testified that there was, the committee asked Connolly to submit an affidavit to the committee, responding to several questions, including the following. Question: in your meeting with Harold Nelson, Jake Jacobson, and George MaryAnn on March 16, 1972, was the subject of campaign contributions from the dairy people to the president's re-election effort, including the amount, form, and timing of such contributions, discussed? Connolly submitted an affidavit to the committee dated April 11, 1974, in which, contrary to his earlier testimony, he states that he now does recall a reference to contributions at the meeting, although he says MaryAnn, not he, initiated the discussion. During Dr. MaryAnn's discourse on AMPI's problems, including internal revenue problems and the antitrust suit which had been filed, as I recall, he made some general comment to the effect that under all the circumstances, AMPI probably should discontinue all political contributions until later. I responded by saying something to the effect that this sounded reasonable. I do not recall any specific discussion of campaign contributions to the president's re-election effort in this meeting, nor a discussion of the amount, form, and timing of any such contributions, except as the general discussion mentioned above can be considered to encompass these subjects. Connolly's advice was consistent with Kalmbach's message to the milk producers that day that Kalmbach was not then accepting further dairy contributions. As Connolly indicates in his affidavit submitted to the committee, the tax matter was discussed at the meeting. Jacobson expressed his opinion that, although there may have been some reference to the IRS matter at the March 16 meeting, and according to Connolly there was, he thought it would have been, quote, improper to talk to Connolly about the pending case. In a conversation with MaryAnn after the March 16 meeting discussed below, Lilly recalls, based on his notes of the conversation, that MaryAnn told him that Connally had called Mitchell during the meeting and that there had been a discussion of a, quote, promise to go slow on IRS, end quote. At the close of the meeting, Jacobson remained behind and conferred privately with Connally for approximately 5 minutes to discuss, in Jacobson's words, quote, Texas politics, end quote. Although Jacobson and Connally say that may have been the occasion on which they discussed Colley representing AMPI on the IRS matter, it now appears, as discussed above, that their discussion took place at some earlier time. C. Lilly's account. Several weeks after the meeting, MaryAnn relayed to Bob Lilly the substance of the meeting with Connally. Lilly has contemporaneous notes which he made of his conversation with MaryAnn, which indicate that it was understood that, as a result of the meeting, the antitrust and IRS matters were going to be resolved in AMPI's favor, and milk producer contributions were to be delayed until later in the year. It is striking how much of Lilly's hearsay account given to the Select Committee in November 1973, the first time the Select Committee learned of the March 16 meeting, has been corroborated by evidence subsequently obtained by the committee. According to Lilly, MaryAnn, Nelson, and Jacobson met with Connally in his office in March 1972, and that in their presence, Connally called Mitchell and discussed 1. Delaying contributions to the Republican Party by AMPI's political trust, 2. Slowing down the antitrust suit against AMPI, and at a later time reducing it to a wrist slap, and 3. Promising to go slow on the IRS audit of AMPI. Lilly says that Connally then called Senator Dole, who, like Mitchell, agreed to defer any obligations due the Republican Party, meaning contributions that might be due, but to delay them until near the general election time. Lilly says he understood that the AMPI representatives had met with Kalmbach too in March. Since the time of Lilly's testimony, the participants in the meeting have acknowledged that the antitrust and IRS matters were discussed, that Connally called Mitchell and Dole and discussed the political implications of these problems, and that Connally at least concurred in a delay in further contributions. Nonetheless, standing alone, Lilly's hearsay account, based upon a report provided by MaryAnn of the understandings allegedly reached on the IRS and antitrust matters, not supported by the participants, might have to be discounted. However, at least that aspect of Lilly's account in connection with the antitrust suit is supported by events several weeks after the meeting. According to Kalmbach and others, on April 4, MaryAnn, whether from a misunderstanding of the discussions on March 16 or from an eagerness to demonstrate to the administration his good faith intention to support the president's re-election effort, contacted Kalmbach and made an attempt to make a substantial pre-April 7 contribution in exchange for assistance in terminating the Justice Department antitrust suit against AMPI, as discussed below. 3. Disposition of the tax investigations. The investigation by the committee has uncovered no evidence of any improper action taken by governmental officials after the March 16 meeting in Connally's office, either with respect to the IRS audit or the case referred to the Justice Department. However, for several reasons apparently unrelated to the Connally meeting, no further IRS audits were undertaken that year, and no criminal prosecution was ever brought for the possible corporate contribution. First, with respect to the IRS, the deductions in question were disallowed, reducing MPI's reported loss for the year 1968. Footnote. When asked of the final result in the IRS matter, Jacobson replied that, quote, a pretty sizable deficiency, unquote, was paid. This, of course, is inaccurate. End footnote. Later, in 1972, responsibility for examining farmer cooperatives was transferred from exempt organization specialists to income tax agents. Accordingly, Bond's responsibility for MPI and AMPI was transferred to another IRS agent, who reviewed the returns for the subsequent years and determined that since AMPI had a loss carry forward of over $1 million for its tax period ending September 30, 1969, there was no, quote, income tax potential, end quote, to justify time-consuming audits, and no additional audits were undertaken at that time. Moreover, it was generally assumed at that time that there were no additional corporate contributions by MPI or AMPI, since the co-op had formed a vehicle for making legal dairy contributions, TAPE, during the 1969 fiscal year, the year immediately following the year that had already been audited. It should be noted, however, that since the completion of the IRS review in 1972, there have been disclosures of additional corporate contributions in the 1968 to 72 period, and full IRS audits of the returns for 1969 forward have been undertaken. In addition, in 1974, AMPI filed amended returns for those years, in which the loss carry forward has been fully depleted in the 1972 return, resulting in substantial taxable income to AMPI, including over $260,000 in 1972 alone. Second, according to Henry Peterson, Assistant Attorney General for the Criminal Division, there was some question about the applicability of Section 610 to the MPI expenditure, but nonetheless, the decision was made by the division in 1972 to investigate it further. Footnote. The book was distributed at the end of 1967, several months before President Johnson announced he was not seeking re-election. Section 610 prohibits a corporate contribution, quote, in connection with any election, political convention, or caucus, end quote. The question was raised by those at the Department of Justice as to the relationship, if any, between the MPI expenditure and the 1968 campaign. End footnote. However, after some investigation by the FBI, the Justice Department file was mistakenly returned to the inactive files of the department and not discovered until 1974, after the statute of limitations to the transaction in question had expired. In any event, Peterson flatly denied any improper conduct by his division in connection with the investigation. Footnote. Peterson and former Attorney General Kleindienst did acknowledge in staff interview that there were several inquiries in 1972 made by Connolly for Jacobson, but with respect to another matter, a pending criminal division investigation of Jacobson's involvement in a possible savings and loan fraud in Texas. Kleindienst remembers being contacted by Connolly and passing on the inquiry to Peterson. Peterson recalls 4 inquiries in all, 2 from then Attorney General Mitchell and then 2 more from Kleindienst. The first after Connolly had called Kleindienst, and the second after a call from the White House to Kleindienst. Peterson says he was upset over the number, although not the content, of these calls. In any event, although it appears that Connolly made these calls on behalf of Jacobson, Peterson says there was no reference to the AMPI IRS matter by Connolly. End footnote. End of Section 35. Recording by Linda Johnson. Section 36 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. E. April 4, 1972. an aborted contribution, and the antitrust suit. George MaryAnn, AMPI's general manager, has stated publicly a number of times that he rejected a request from Kalmbach that AMPI make a further contribution to the president's campaign, and that his refusal helped precipitate the Justice Department's decision to file the antitrust suit. None of the evidence uncovered by the committee or apparently by the special prosecutor supports that contention. Footnote: the suggestion that political contributions in any way influenced the Justice Department's decision to file the civil antitrust suit against AMPI is not supported by any documents in the possession of the Justice Department or the special prosecutor. John Sale, Assistant Special Prosecutor, Watergate Special Prosecution Force, has filed an affidavit in the antitrust suit in response to a motion by defendants for production of documents. Sale's affidavit states the following: I am familiar with all the documents and recordings in the possession of the Watergate Special Prosecution Force relating to political contributions from milk cooperatives. None of these documents or recordings support AMPI's allegations that United States v. AMPI was filed for the purpose of inducing representatives of AMPI to cause the Trust for Agricultural Political Education, TAPE, to make campaign contributions directly or indirectly to individuals or organizations involved in the raising of funds for the re-election of President Nixon. End footnote. In fact, as explained above, the evidence tends to show that the Attorney General made several decisions favorable to the dairymen after he had become fully aware of AMPI's past and promised support for the campaign effort, and after he had consulted with Haldeman and perhaps others on the possible impact of an unfavorable decision on further contributions. MaryAnn did not even meet with Kalmbach until after the suit was filed, and it was not until the day the suit was filed that Haldeman was informed that the dairymen were not going to contribute the full $2 million. What's more, there is evidence that AMPI not only tried to use its political influence to delay the filing of the suit, but that, after it was filed, MaryAnn offered to make a substantial contribution in exchange for assistance from the White House on the suit. 1. Pre-April 4 discussions. After the antitrust suit was filed, AMPI representatives such as MaryAnn and Murray Chotiner expressed their unhappiness over the suit to a number of administration representatives, including Mitchell, and, as noted above, Kalmbach and Secretary Connolly. At the same time, discussions about additional contributions continued. A. Kalmbach, Jacobson, and MaryAnn. At the February 3 meeting with Kalmbach, when the additional $750,000 contribution was discussed, MaryAnn apparently talked to Kalmbach about the antitrust suit, who, according to Jacobson, was, quote, sympathetic. Jacobson says that MaryAnn did not want to give to the president's campaign after the administration had filed suit against him, and that MaryAnn told that to Kalmbach. Footnote: neither MaryAnn nor Kalmbach recall discussing the antitrust suit at the February 3 meeting, although Kalmbach did discuss the matter with Mitchell, with whom he was discussing his solicitations of the milk producers. End footnote. Nonetheless, there is evidence that MaryAnn felt that a contribution was wise or obligatory to fulfill prior commitments and in view of the antitrust suit. As noted above, he told Isham early in 1972 that they were going to have to contribute, and Jacobson says MaryAnn told him that he hoped the contribution would help alleviate the milk producers' problem with the antitrust suit. B. Chotiner and Mitchell. AMPI did not limit itself to one line of contact with the administration about the antitrust suit. In addition to Jacobson contacting Kalmbach, MaryAnn Harrison and Murray Chotiner were contacting the top officials at the Justice Department, including Attorney General Mitchell. In late January 1972, several weeks after MaryAnn had replaced Nelson, Harrison flew to San Antonio and met with MaryAnn in an attempt to solidify his firm's relationship and its $108,000 per year retainer with the new management. MaryAnn says that Harrison told him that he had played a major role in arranging for the dairy contributions the previous year, although, according to MaryAnn, Nelson and Parr had expressed to MaryAnn their opinion that Harrison had been, quote, ineffective, end quote, with respect to those contributions. In any event, additional contributions were discussed, and Harrison gained the impression that MaryAnn did not want to make any further contributions for the president's campaign. At about the same time as the Harrison-MaryAnn discussion of contributions, Stuart Russell, one of AMPI's counsel who was engaged in pre-filing negotiations with the Chicago office of the Justice Department, contacted Harrison and asked him to see if anything could be done before the suit was filed. Before Harrison could act, however, the suit was filed. Harrison then talked to Chotiner, who was counsel to the Harrison firm and who had also been involved in the dairy contribution and price support activities the previous year, and the two agreed that since Richard Kleindienst had been nominated to replace Mitchell, who was leaving to head the president's campaign effort, they should await Kleindienst's confirmation and then speak to him about the suit. The next night, February 24, 1972, Chotiner met Mitchell at a so-called, quote, Agnew Sinatra, end quote, cocktail party, and asked him about the suit. According to Chotiner, Mitchell merely puffed on his pipe. Mitchell says he attended the party but does not recall any discussion with Chotiner. Footnote. As noted above, Mitchell, in a staff interview, said that the only person other than Kalmbach with whom he would have discussed the milk producers' situation was Chotiner. End footnote. Although Chotiner's description of Mitchell's response seems to indicate that the conversation was probably insignificant and definitely one-sided, Harrison thought the meeting was important enough to describe Chotiner's account of it to George MaryAnn in a letter dated the next day, February 25, 1972. The letter reads, in view of the changing of the guard apart from Jake's reasoning, I decided, with Murray's concurrence, not to talk with the incumbent, but to take the matter up anew with his successor. Then Murray ran into John at the Agnew Sinatra party. They had a tete-a-tete on another matter, and this subject came up. The version of the facts I surmised to you by telephone is confirmed. I guessed right. The confirmation vote will be no earlier than February 29 and probably later next week. After that, I'll go see the new management. In a week or two, I'll endeavor to zero in. Harrison explained that his, quote, version of the facts was that McLaren was responsible for filing the suit, and that Mitchell had merely signed off on the suit and knew little about the circumstances of its subsequent filing. Harrison also says that his reference to, quote, Jake's reasoning, unquote, was to the fact that Jacobson felt nothing could be done about the suit. However, Jacobson testified that he does not know what was meant by, quote, Jake's reasoning, and that, contrary to Harrison's view of his, quote, reasoning, he felt political contributions could help AMPI in all its problems, including the antitrust suit. Because of the ITT scandal, Kleindienst was not confirmed by the Senate until June 8, 1972, after which Harrison was to, quote, zero in and see the new Attorney General, which he did. Apparently nothing came from that contact, and at the end of June, AMPI fired the Harrison firm because, according to Chotiner, it did not get a good response for AMPI from the administration. 2. April 4 meeting and contacts with Kalmbach about the antitrust suit and contributions. Despite MaryAnn's alleged reluctance to contribute to the president's campaign, and despite his conversations with Kalmbach and Connolly on March 16, There is evidence that MaryAnn made one last effort prior to April 7 to make a substantial contribution in order to secure White House intervention in the antitrust suit. According to Lily and Nelson, a meeting was held on April 4 in MaryAnn's office to discuss the matter, and as a result of the meeting, checks for a $150,000 contribution to the president's campaign were drawn but later voided after Kalmbach says he rejected MaryAnn's offer of a quid pro quo involving the antitrust suit. A. The meeting. Present at the April 4 meeting were MaryAnn, Lily, Nelson, and perhaps for part of the meeting, Lynn Elrod, another AMPI employee and assistant to MaryAnn. Lily says that at the meeting it was decided that prior to April 7, Nelson was to deliver a total of $300,000 from the three dairy trusts, $150,000 from TAPE, $100,000 from ADEPT, and $50,000 from SPACE. Before consenting to make a contribution, MaryAnn called John Butterbrodt, AMPI's president, to obtain his approval. As related by Lily, MaryAnn also wanted to talk to Kalmbach so that he and all Republicans would know that AMPI was not welching on its commitment made the previous year in connection with the milk price support decision. Lily added, quote, "Further, MaryAnn stated he expected the Justice Department to slow down its antitrust suit against AMPI and later reduce it to a wrist slap." End quote. Lily says that MaryAnn then called Jacobson in Austin and asked him to contact Kalmbach to arrange for the contribution. Jacobson called MaryAnn back and told him that Kalmbach would call him that night. In the meantime, 30 checks, each for $5,000 for a total of $150,000 were drawn, but with the names of the payees left blank, awaiting committee names from Kalmbach. That morning, however, Robert Isham, the sole TAPE trustee, had resigned to avoid having anything to do with the contemplated contribution. As a result, the checks were drawn on the account of AMPI's new political arm, CTAPE, which was then being organized to replace TAPE, and were signed by the two signatories on the recently opened CTAPE account, MaryAnn and Elrod. Footnote: at the time the checks were drawn, there were insufficient funds in the CTAPE account to cover the checks. However, there were ample funds in the TAPE account, and under the TAPE trust agreement, the AMPI board had the authority to appoint a new trustee who could either have written the checks on the TAPE account or have transferred the funds to the CTAPE account to cover the checks after they had been delivered, but before they had been cashed by the president's campaign committees. In fact, at the April 12-13 meeting of the AMPI board, MaryAnn was appointed trustee for TAPE, and throughout the remainder of 1973, TAPE transferred over $1 million to the CTAPE account. End footnote. Lily says that since only 26 checks were in the CTAPE checkbook in San Antonio, he had to contact Jacobson in Austin to have 4 blank checks delivered that day from the Citizens National Bank, of which Jacobson was chairman. Late in the afternoon, at 4 or 4:30, John Parker, an officer at the bank, called Lily and told him that another bank employee, Don Wallace, would deliver the extra 4 checks. At about 6 p.m., Wallace arrived at AMPI and delivered the checks, which were completed by an AMPI secretary, Verna Polk. It then appears that Elrod signed the 4 checks and took them to MaryAnn's home that evening for his signature before MaryAnn left San Antonio early the next morning for an AMPI meeting in Fond du Lac, Wisconsin. The 30 checks were voided within a day or two by Elrod at MaryAnn's direction and never delivered. Although MaryAnn and Elrod readily concede that fact, both claim they have no recollection of why they were drawn in the first place or later voided. However, by Kalmbach's and Lily's accounts, MaryAnn did speak that evening to Kalmbach, who rejected MaryAnn's offer of a quid pro quo. B. Kalmbach's call to MaryAnn. Kalmbach says that on or about April 4, Jacobson talked to him by telephone and asked him to call MaryAnn. When Kalmbach made the call the same evening, Kalmbach says that MaryAnn told him that he was ready to make a substantial contribution, but that he had wanted to talk to Kalmbach before doing so. MaryAnn expressed concern over the antitrust suit and asked him to speak to someone at the White House on AMPI's behalf. Kalmbach understood the message. The contribution was to be made in order to have Kalmbach contact the White House for help on the antitrust suit. Kalmbach says he rejected MaryAnn's offer and request. At that point, according to Kalmbach, MaryAnn appeared particularly frustrated and said something to the effect that, quote, "Here you're asking for contributions and you're not willing to help," end quote. The conversation then ended rather abruptly. Kalmbach says he reported to Ehrlichman that he had broken off contact with, quote, the milk people because they were seeking a quid pro quo, and that Ehrlichman had told him, quote, "That's good judgment," end quote. Footnote. Kalmbach is not sure whether he reported this to Ehrlichman after his March 16 meeting or April 4 conversation with MaryAnn. If it was between March 16 and April 4, Kalmbach says that he anticipated that AMPI would request a quid pro quo, which he says MaryAnn did on April 4. End footnote. Although he thought it had occurred before 1972, Ehrlichman did recall such a conversation with Kalmbach. C. Corroboration of Lilly's account. On November 16, 1973, Lilly testified in executive session that MaryAnn had told him, shortly after April 4, 1972, that Kalmbach had called him and refused the contributions, just as Kalmbach testified before the committee 4 months later in March 1974. As in the case of several other incidents investigated by the committee, Lilly's account of the meeting and of the call from Kalmbach on April 4 have been corroborated by independent evidence, most of which was unknown and unavailable to Lilly at the time he testified. This corroboration includes the following. MaryAnn's logs. MaryAnn's logs indicate that a meeting was scheduled and held in his office on April 4 involving himself, Nelson, Lilly, and possibly Elrod. MaryAnn concedes that the meeting took place, but says he cannot recall the subject of the meeting. Butterbroat's telephone records. Lilly testified that MaryAnn conferred with Butterbroat on the $150,000 C-tape contribution. Butterbroat confirms that after the February 3 meeting with Kalmbach, MaryAnn told him that money could be contributed secretly to the president's campaign prior to April 7 via state committees, but since they had agreed to reject that approach, MaryAnn did not discuss another contribution with him on April 4. However, Butterbroat's telephone records indicate that he called the San Antonio Home Office twice on the morning of the 4th, and he assumes that, as Lilly testified, he talked to MaryAnn at least one of those times. Nelson testimony. Like Lilly, Nelson has testified that he attended the meeting on April 4, and that MaryAnn did not want to contribute the $150,000 unless he was able to speak to Kalmbach to see if he could help them with the antitrust suit. Footnote. Nelson does not recall any discussion at the meeting of a total of an additional $150,000 from Adept and Space. End footnote. The voided checks. The C-tape records reflect 30 checks, each for $5,000 drawn in blank, signed by MaryAnn and Elrod, and voided by Elrod. Employees at the Citizens National Bank, John Parker and Don Wallace, and at AMPI, Verna Polk and Lynn Elrod, confirm Lilly's account that 4 of the 30 checks were delivered to AMPI from the Austin Bank late on the afternoon of the 4th and apparently rushed to MaryAnn's home for him to sign them that evening. Kalmbach's telephone logs. The records of Kalmbach's telephone calls and the appropriate records of the San Antonio and Austin telephone companies reflect that on April 4, Kalmbach called both Jacobson and MaryAnn. Footnote: during 1972, Kalmbach charged some of his telephone calls concerning the campaign to an RNC credit card, and a committee search of the RNC records revealed for the first time to Watergate investigators that he charged calls to one number in San Antonio and one in Austin on the 4th. A committee check of the telephone records for the San Antonio and Austin telephone companies revealed that on April 4, 1972, those numbers were listed for George MaryAnn and Jake Jacobson, respectively. End footnote. Dwight Morris, Butterbrodt conversation. The committee has uncovered further evidence to corroborate the account of MaryAnn's attempt to secure a quid pro quo. In response to a committee questionnaire to present and former AMPI directors and employees, former AMPI official Dwight Morris stated, and later testified before the committee, that John Butterbrodt discussed the matter with him 1 week after it occurred. Morris had been secretary to the board of AMPI and vice president of the Southern Region and Arkansas Division of AMPI until February 1972, when he became active with some of Parr's former assistants in a rival dairy co-op group in Arkansas, the Southern Milk Producers Association. Morris says that AMPI was attempting to squelch the revolt and absorb the rival group, and that Butterbrodt met with him in Chicago on April 11, 1972, to try to work out their differences. In the midst of the conversation, Butterbrodt referred to the antitrust suit and told Morris of AMPI's efforts to handle it. Butterbrodt allegedly told Morris that AMPI representatives had gone to Washington to see what could be done about the suit and spent a couple of days speaking to people at the Justice Department and elsewhere, but no one would enter into a, quote, meaningful conversation with them. Footnote: Morris said that he thinks Butterbrodt told him that MaryAnn, he, and perhaps Nelson had gone to Washington and then met with Kalmbach, but he may just have assumed that Butterbrodt personally was involved, and that Butterbrodt's reference to "we" may have been merely a reference to AMPI's representatives other than himself. There is no evidence that Butterbrodt personally participated in conversations with Kalmbach. End footnote. Morris testified that Butterbrodt told him, "Finally, after making the rounds, someone suggested that the real way to solve their problem would be to talk to Mr. Kalmbach. They met with Mr. Kalmbach and came to an agreement that AMPI would pay $300,000 to Kalmbach, and that as a result of that, the antitrust suit against AMPI would go away. The AMPI representatives came back home with the understanding that Mr. Kalmbach would direct them where or to whom to send the money, and before that could be accomplished, the ITT thing hit the press, and Mr. Kalmbach sent word to AMPI that he did not want their money." Although Butterbrodt does not recall telling these details to Morris, he concedes that he may have discussed contributions with Morris at their meeting. Furthermore, he says that he knew that MaryAnn and others had met with Kalmbach and Connolly, and that they had discussed pre-April 7 contributions with Kalmbach. There is evidence, then, that AMPI's top officials sought, through Kalmbach, high-level White House assistance on the antitrust suit in exchange for a substantial and secret pre-April 7 contribution. This time, Kalmbach, after nearly 3 years of hearing of milk producer pledges and contributions linked to favorable decisions by the administration, backed away. At the time of the ITT scandal, and in view of the damaging publicity in connection with the previous year's dairy contributions and price support activities, Kalmbach decided to try and prevent another milk producer scandal. As a result, no further dairyman contributions were made to the president's campaign for several months, and there is no evidence that Kalmbach or any White House official intervened in the antitrust suit thereafter. Footnote. In fact, there is evidence that later in 1972, at least one White House official viewed the progress of the antitrust suit as a, quote, positive offset to adverse publicity over the, quote, milk deal the year before. End footnote. End section 36. Recording by Linda Johnson.
Section 37 of the Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Greg Giordano. Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2, Chapter 5, Milk Fund, Part 21. Milk producer contributions to the President's campaign after April 7, 1972. For the duration of 1972, the milk producers reportedly contributed another $95,000 to the President's campaign, primarily due to the solicitation efforts of Lee Nunn and Clayton Yoder of FCRP, and Jacobson and Connolly on behalf of Democrats for Nixon. In addition, just prior to the election, Lee Nunn of FCRP solicited from CTAPE a presidential contribution of as much as $650,000 or $750,000, allegedly in satisfaction of the earlier dairy commitment dating back at least to March 1971. In late October 1972, CTAPE contributed approximately $350,000 to Republican congressional committees, and about the same time, these committees transferred about $200,000 to the RNC and then to the FCRP. While there had been transfers totaling $650,000 from RNC committees to the congressional committees some weeks before, and there is some evidence that the $200,000 was in repayment of those earlier transfers, a number of the RNC, senatorial, and congressional committee officials involved were not aware of any relation between the transactions. There is also other evidence that the movement of the dairy money to FCRP was part of a plan arranged by Nunn and possibly Stans to divert the CTAPE congressional contributions to the President's campaign. There is no evidence that any other officials connected with the congressional, senatorial, or Republican national committees knew the circumstances of the solicitation of the CTAPE contribution or considered the contribution related to any dairy commitment to the President's campaign or to governmental action favorable to the dairy industry. A significant result of the manner in which these dairy trust contributions were made, particularly those to FCRP, made after the last pre-election reporting date, and the CTAPE contributions routed through the congressional committees, was that an additional link between dairymen and the President's campaign was kept from public view prior to the election. A. $95,000 from Adept and Space. Late in the summer of 1972, leaders of both DI and Mid-Am met with Connolly, then head of Democrats for Nixon, and apparently discussed some of their problems with the administration and committed $50,000 to his organization, which was contributed almost immediately thereafter. Meanwhile, FCRP officials Lee Nunn and Clayton Yoder, who had taken over certain of Kalmbach's solicitation responsibilities, were arranging for another $45,000 to be contributed by the dairy trusts of the two co-ops just prior to November 7th, after the final pre-election reporting period had ended. 1. Meeting with Connally and $50,000 for Democrats for Nixon. In an August 7, 1972 CRP memo, there appears a list of the subgroups of the agribusiness industry covered by the President's campaign fundraising effort with the following notation, quote, milk producers, Lee Nunn and John Connally handling, end quote. 5 days earlier, Connally, who headed Democrats for Nixon, had met with a number of dairy co-op officials. Connally's log for August 2, 1972, lists a meeting with Morgan and Westwater of DI, Gene Baldy, general manager of Mid-Am, Hanman, also of Mid-Am, and MaryAnn of AMPI. MaryAnn did not attend, but Parr, by that time employed by DI, did. One of the principal outcomes of the meeting was the making of additional milk producer contributions to Democrats for Nixon. Jacobson, who was assisting Connally in the Democrats for Nixon organization, says that the Mid-Am and DI officials contacted him and said that they wanted to make a contribution to Democrats for Nixon and to FCRP, but that they wanted to talk to Connally first. Jacobson informed Lee Nunn of FCRP and arranged the meeting with Connally, as he had done on a number of occasions earlier in the year in connection with fundraising meetings between the milk producers and Kalmbach. Officials of the two co-ops had discussed the matter of contributions to Democrats for Nixon and came to Washington to meet Connally and ready to announce their commitment of $25,000 each. Footnote: See Hanman, 14 hearings, 5892 to 5893 and 5895. End of footnote. In fact, Westwater says that he brought the $25,000 space check with him to Washington. At the meeting, the dairy officials told Connally of what they considered the negative attitude of the administration toward dairy co-ops on a number of matters, including possible antitrust violations. They say they also discussed contributions to the president's campaign. Hanman says that although he had not intended to announce a commitment for a contribution, he and the DI representatives did so at Connally's request. Mr. Hanman: I think Mr. Connally asked us if we were going to make a commitment, a contribution. He indicated that he was going to have a party in Texas somewhere where the president would be there. He would like for some of us people to be there. Senator Montoya: with the money? Mr. Hanman: No, he was inviting only those people, I think, who were going to make some contributions. And as I recall as the way the meeting developed, that's how we got to the $25,000. It was an opportunity to get to this dinner and meet the president and meet some of his supporters, and I believe that's about the way it developed. In direct contradiction to Hanman's sworn testimony, Connally testified that although there may have been a passing reference to milk producer support, quote, the meeting in no way on August 2nd was a meeting that dealt with political contributions, end quote. Mr. Weitz: You are certain of that? Mr. Connally: I am certain of that. Connally testified that, in fact, he did not even know of the two $25,000 contributions. However, aside from the testimony of Hanman, the records of Space, DI's trust, indicate that it contributed $25,000 to the National Democrats for Nixon on or shortly after August 2nd, the day of the Connally meeting. In fact, Westwater says Connally personally accepted the $25,000 space check sometime shortly after the meeting. Despite Connally's testimony before the committee that at about the same time he refused to use the $10,000 cash for Democrats for Nixon, which Lilly of AMPI had in 1971 given to Jacobson for Connally's designation for political campaigns. On September 19, ADEPT MaryAnn's Trust, contributed $25,000, $6,000 to the national organization, and $19,000 to 4 state Democrats for Nixon committees. Connally testified that he was told only of the contributions to the national organizations, $25,000 from Space and $6,000 from ADEPT. However, Hanman testified that at the August 2nd meeting, Connally solicited and Hanman committed $25,000 from ADEPT, in addition to the $25,000 Space commitment, and Jacobson has testified that he thinks he informed Connally of both $25,000 contributions when they were made. Footnote: Hanman, 14, hearings, 5893. Jacobson, 15, hearings, 6475. Connally also denied tying invitations to a September reception at his ranch he was planning for the president to additional contributions. Quote, "No invitation to that meeting was tied to a contribution of one thin dime." End quote. To the contrary, Hanman testified that Connally raised the subject of the reception in connection with contributions, and the dairy officials responded with their commitments. Moreover, the Space and ADEPT contributions were completed by September 19, and representatives of both co-ops attended the reception several days later. Footnote: Hanman, 14, hearings, 5893, 5896 through 97. The reception was held on September 22, 1972. End of footnote. 2. $45,000 to FCRP. On May 1, 1972, Jacobson and 2 DI officials, Ben Morgan, who had replaced Paul Alagia the previous year as executive director, and Joseph Westwater, flew to California and met with Kalmbach. Footnote: Those attending the meeting agree it took place in the spring or early summer of 1972. Westwater says in a staff interview that it was in May, and Kalmbach's logs, in the committee's possession, indicate that the only meeting with Jacobson that month was on May 1st. End of footnote. Jacobson says that Morgan and Westwater had told him that they wanted to make a contribution to the president's campaign, and he made an appointment for them with Kalmbach. While it is not clear whether political contributions were discussed at the meeting with Kalmbach, it appears that no effort was made to collect any further contributions to FCRP from ADEPT or Space until several months later, when Clayton Yoder, a former USD official and a CRP official responsible for farm interest groups, became involved in fundraising. In late summer 1972, Yoder contacted Westwater of DI and Gary Hanman of MaryAnn to solicit contributions, and each co-op's trust made a contribution just prior to the election. On October 28, Space contributed $25,000 to FCRP, and on November 6, the day before the election, ADEPT contributed $4,000 to each of 5 state FCRP committees for a total of $20,000. Footnote: See Kima Affidavit Supra. The $25,000 from Space may have been used to pay for CRP campaign leaflets. In a September 6, 1972 memo from Yoder to campaign official Fred Malick, Yoder referred to the printing and distribution of 500,000 copies each of 2 agricultural campaign leaflets. Quote, "President Nixon, the right choice for America's farmers," end quote, and quote, "Nobody bullies butts," end quote, costing approximately $15,000 to be paid by DI, quote, "one of the dairy cooperatives that has been most friendly to the administration," end quote. Yoder Memo, 17 Hearings, 8167. According to the memo, Stan suggested that the November Group, a public relations organization for the president's campaign, contract with the printer, and that DI paid the printer directly for the pamphlets which it would then deliver to CRP as a campaign contribution in kind. Westwater says that although he did discuss the printing and the contribution with Yoder, and he later received copies of the pamphlets from Yoiter before they were distributed, he does not remember whether the contribution was to pay for the pamphlets. However, a search of the DI and space files has revealed no direct expenditure to the printer. End of footnote. Because of the timing of the contributions, they were not publicly reported until well after the election. According to federal election laws, final pre-election reports must be filed by political committees 5 days before the election covering contributions made up to 12 days before the election, and in the case of the 1972 presidential election, October 26, 1972. Westwater said in a staff interview that although Yoiter met with him well in advance of October 28 to discuss the contribution, Westwater delayed delivery of the check until October 28, and this may have been at Yoiter's suggestion. Westwater says he may also have discussed the matter with Gary Honman of Mid-Am and MaryAnn Harrison, whose firm had been retained by Mid-Am and DI. B. $200,000 to the President's campaign. AMPI's trust CTAPE was also solicited for a last-minute pre-election contribution, with the ultimate result that $200,000 of CTAPE money was furnished to the President's campaign. After the ITT scandal and the Watergate break-in, there was increased concern among White House officials about damaging disclosures in connection with the milk case. On August 31, 1972, for example, in a memorandum to Haldeman, Ehrlichman, Colson, Clark McGregor, Stans, and Whitaker on the progress of the Nader milk suit, Dean noted that as a result of possible depositions of ex-Secretary Hardin, Chotiner, Colson, Whitaker, and others, and attempts to obtain internal White House papers, quote, "The potential for political embarrassment during the remaining months of the campaign is high." End quote. Footnote. Strachan Exhibit 14, 16 hearings, 7511. In a staff interview, David Wilson, former staff assistant to the President and aide to Dean, said that he had reviewed some White House milk documents for Dean to determine the extent the claim of executive privilege would be asserted. Although Wilson says he saw only one reference to the documents to political contributions, the March 22, 1971 memo from Whitaker to the President, described in Section 1V.F.3 above, he did not have access to Colson's file. As noted above, Dean, who did, apparently considered the materials damaging. End of footnote. Dean also noted, quote, "on the positive side," end quote, from the White House point of view, that the Justice Department antitrust suit was proceeding quickly and that, quote, "this vigorous prosecution shall call into question any allegations by Nader that the milk producers have influenced the administration by their political contributions." End quote. Footnote. Strachan, Exhibit 14, 16 hearings, 7512. Dean reported that the suit might be ready for trial by the spring of 1973. In mid-1974, pretrial discovery proceedings were still underway, apparently not because of any less vigorous prosecution, but because of two independent factors. 1. Since issues were raised in the suit about the impact of AMPI political activities on the suit itself and other governmental matters involving AMPI, pretrial discovery became concerned with AMPI's political activities. 2. There are allegations, some of which have been substantiated in committee testimony and staff interviews, that AMPI employees willfully destroyed company documents in the spring of 1971 and possibly early 1972 to hide certain damaging evidence from government and other investigators. See Parr, 15 hearings, 6894 through 96. Murphy interview, December 11, 1973. End of footnote. Despite concerns at the White House over presidential links to the milk producers, another contribution from AMPI's political committee to the president's campaign was solicited from George MaryAnn, AMPI's general manager, by Lee Nunn, vice chairman of the Finance Committee to re-elect the president, just prior to the election, to fulfill the previous commitment made in connection with the 1971 milk price support decision, according to accounts of a number of the participants in the events, including Bob Lilly, who, as secretary for CTAPE, was briefed by MaryAnn in late October 1972 and made contemporaneous notes. Nunn asked MaryAnn for the balance of the commitment from AMPI that dated back to 1970 and 1971. To help meet the commitment, MaryAnn agreed for CTAPE to contribute $300,000 to congressional committees, which, according to Lilly, was to go primarily for the president's re-election effort. 1. Nunn-MaryAnn meeting. Lee Nunn had been involved in arranging for the milk producer contributions in 1971, and, according to the August 7, 1972, CRP memo noted above, he and Connolly were handling the milk producers. In early August, Connolly had met with MidAm and DI officials and obtained $50,000 in contributions from them. Nunn apparently focused his attention on AMPI, which, as he stated, quote, sort of controlled what the others did, end quote. Nunn says that after the Republican National Convention, Stans pressed his presidential campaign fundraisers to solicit more money to offset what Stans considered a likely campaign debt of as much as $10 million. Nunn offered to solicit a contribution from AMPI, and he thereupon contacted MaryAnn Harrison, who referred him to Jacobson, who in turn put him in touch with MaryAnn. This contact with MaryAnn appears to have been part of the coordinated effort of FCRP and Democrats for Nixon to solicit the three major dairy co-ops for more money just prior to the election. MaryAnn says that during the week of October 17, Jacobson called him and arranged a meeting between him and Nunn, whom MaryAnn believes Jacobson described as Kalmbach's replacement as the chief Republican fundraiser. Footnote: MaryAnn, 16 hearings, 7288-89. Jacobson conceded that he talked to Nunn, but denied calling MaryAnn. Jacobson, 15 hearings, 6477. End of footnote. On Saturday morning, October 21, Nunn flew to San Antonio and met MaryAnn in his office. Nunn opened the meeting by explaining that he had replaced Kalmbach at FCRP and by stating that the projected presidential campaign debt was $10 million, due in large part to the media expenses at the CRP media arm, the November group. Footnote: Nunn, 17 hearings, 7556-57. MaryAnn, 16 hearings, 7294-7296. MaryAnn says Nunn told him they were already $3.5 million in debt and would reach a $10 million debt by the end of the campaign. MaryAnn, 16 hearings, 7296. The campaign ended with a several $million surplus. End of footnote. Although Nunn does not recall requesting a specific amount from AMPI, MaryAnn said Nunn asked for $650,000. MaryAnn says that Nunn attached to his request the following statements. Quote, well, it never could be quid pro quo, and never would be. It is correct that the president does remember his friends who helped him. End quote. According to MaryAnn, quote, that is as close to a quid pro quo statement as I think anybody ever came to me. End quote. MaryAnn says he told Nunn that while the committee for TAPE had voted not to make any additional presidential contributions, but only congressional contributions, he would relay Nunn's request to the committee members and advise Nunn of their decision. Nunn says that in view of AMPI's reluctance to contribute to the president's campaign, he made a pitch to MaryAnn for contributions to Republican congressional candidates, apparently deciding not to make a direct appeal to the CTAPE members to reverse the earlier vote. Nunn suggested several candidates who particularly needed funds for the remaining days of their campaigns, but MaryAnn was antagonistic to some of them. Nunn is not certain whether it was at this point or later that MaryAnn nonetheless told him that he would recommend that CTAP contribute $150,000 each to the Republican senatorial and congressional campaign committees for the use of whatever Republican candidates the committees selected. presumably including those candidates whom MaryAnn opposed. But before the contributions were made, MaryAnn conferred first with former President Johnson, then his fellow CTAP officials, including Bob Lilly. 2. LBJ MaryAnn meeting. MaryAnn held several high posts in President Johnson's administration, including that of Assistant Secretary of Agriculture. Although MaryAnn did not do so often, he says he decided to meet with the former president because he began to wonder whether his refusal to contribute to President Nixon's campaign would jeopardize the co-op. Immediately after Nunn left, MaryAnn flew to the LBJ ranch and met with President Johnson on the afternoon of the 21st, pursuant to an appointment he had made immediately after Jacobson had set up his meeting with Nunn earlier in the week. MaryAnn says he described to President Johnson his meeting with Nunn, including Nunn's reference to a large campaign debt, to which he responded incredulously, quote, "Do you really believe that?" End quote. MaryAnn answered, quote, "You didn't ask me what I believed. You asked me what Mr. Nunn had said." End quote. MaryAnn concedes that, despite his claim that he knew of no prior commitments, they discussed the very subject of dairy co-op commitments to President Nixon's campaign. MaryAnn says that when he raised the subject with Johnson, the latter's advice was that, quote, "If there be a commitment, he considered it our obligation, not mine personally, the TAPE obligation, and we should meet it." End quote. MaryAnn attempted to explain how he came to discuss with President Johnson the subject of supposedly non-existent commitments. "I had begun to see a sequence of Jacobson, and on a peripheral basis, at least, Nelson. I kept saying to myself, why? After the Kalmbach matters, why would Jacobson be so persistent in this? For some reason or other, these people found it necessary to try to get dairy money into the Republican campaign." As a result of their meeting, MaryAnn says that he, at President Johnson's suggestion, agreed that CTAP should make additional congressional contributions and that the trust should balance its total contributions for the year to both parties. MaryAnn says that the former president also noted that these congressional contributions could benefit the presidential campaigns without further linking CTAP to the presidential campaign, by being used to pay for the expenses of campaign events attended by both congressional and presidential candidates. MaryAnn says that subsequently he conferred with his CTAP officials and obtained their approval for that approach. One of those with whom MaryAnn conferred was Lilly, Secretary of CTAP, who testified to one significant additional detail, that the plan also included the diversion of some of the milk contributions from the congressional races directly to the president's campaign effort. Because of that, Lilly says that he objected. His account of the MaryAnn meetings varies in some important respects from MaryAnn's and Nunn's. 3. Lilly-MaryAnn meeting. On October 23, 2 days after his meeting with Nunn and the former president, MaryAnn met with Bob Lilly and related to him the substance of the two meetings. According to Lilly's contemporaneous notes, there were several key items omitted by MaryAnn and Nunn in their testimony, which indicate that the contributions solicited and finally made were expressly for the president's campaign in satisfaction of the prior commitment made for the 1971 price support increase. As testified to by Lilly before the Select Committee on November 16, 1973, Nunn asked MaryAnn to contribute $750,000 for the, quote, obligation for the blank 1971 price support, end quote, decision, and he suggested several alternatives: $750,000 to Democrats for Nixon, or the committee to re-elect the president, or $325,000 each to the Republican congressional and the Republican senatorial campaign committees. To MaryAnn's account of his meeting with President Johnson, Lilly added the significant element that MaryAnn told him he had gone to see Johnson, quote, to discuss the commitment of $750,000 to the Republican Party from a carryover from 1971, end quote, and that it was in that context that the former president responded, quote, if you made the commitment, well then fulfill it and carry it out, regardless of how hard that might hurt." End quote. On the question of commitments, Lilly stated he was told by MaryAnn that President Johnson discussed a $250,000 milk producer commitment to him, presumably in the 1964 campaign, which he wanted fulfilled. President Johnson allegedly indicated a detailed knowledge of the AMPI producer's checkoff system and told MaryAnn the commitment could be met by means of deductions from the producer's checks. MaryAnn acknowledged that President Johnson discussed the earlier commitment but denied that the former president either considered it an outstanding obligation or mentioned any system of raising monies by a checkoff of dairy producers to meet that prior commitment. Although Lilly testified that he could not explain the discrepancy between the $750,000 none allegedly requested for Democrats for Nixon, or FCRP, versus the total of $650,000 none requested for the congressional committees, other evidence in the committee's possession supports the conclusion that the $750,000 and $650,000 figures were both related to the prior commitment for the 1971 milk decision. It should be recalled that in February 1972, Strachan reported to Haldeman that Kalmbach was making arrangements for the milk producers to contribute the remaining $750,000 to reach the modified commitment of $1 million. Due to the ITT scandal, further contributions were delayed until just prior to the election. By the time of the Nunn-MaryAnn meeting, an additional $50,000 had recently come in from the trusts of the other two co-ops, Adept and Space, to Democrats for Nixon, and a like amount was expected from them for FCRP. Footnote. Another $45,000 was contributed by Space and Adept to FCRP within the next 2 weeks. See sections VII A Supra. End of footnote. Thus, consistent with Lilly's notes, $650,000 of the $750,000 commitment was still needed to enable the milk producers to meet their obligation, which had originated a year earlier in connection with the 1971 milk price support decision. Instead of the $650,000, a total of $300,000 was contributed, the same amount that, according to Lilly, was proposed by AMPI for the president's campaign just prior to April 7, 1972, in connection with the antitrust suit. The public records of CTAPE show it going to Republican congressional committees. There is evidence that, in fact, an FCRP official diverted most of that money through the committees onto the Finance Committee to re-elect the president. End of Section 37. Recording by Greg Giordano. Newport Richey, Florida. Section 38 of The Watergate Report, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Greg Giordano. Final report of the Senate Select Committee on Presidential Campaign Activities, Volume 2. Chapter 5, Milk Fund, Part 22. 4. $350,000 to Republican congressional committees, alleged $200,000 pass-through to FCRP. After conferring with Nunn, President Johnson, and Lilly, MaryAnn says he decided to have C-Tape make a substantial contribution to the Republican congressional committees and communicated his decision to Nunn and apparently Lilly. However, Lilly understood that the October 1972 contributions to the Republican congressional committees went instead to the president's campaign. Footnote. Lilly, 14 hearings, 6128. Lilly affidavit, 14 hearings, 6218-20. In November 1973, when Lilly testified to this effect, neither the Select Committee nor its staff had spoken to any of the other participants in the matter. and had not yet obtained the documentary evidence relating to the disposition of the money by the Republican congressional committees and RNC, which is consistent with Lilly's account. End of footnote. Although both MaryAnn and Nunn deny it, other evidence in the possession of the committee supports Lilly's account and indicates that the diversion of most of the milk money to FCRP was done with the tacit, if not express approval of MaryAnn, and was contemplated from the inception of the transaction by Nunn. A. Milk Producers' Version. According to its records, the Committee for Tape decided on October 11, 1972, 10 days before the Nunn-MaryAnn meeting, that no further contributions were to be made to presidential candidates, and that instead $25,000 would be contributed to each of the Republican and Democratic senatorial and congressional campaign committees, for a total of $100,000. On October 17, the two Democratic contributions were made, but no action was taken on the Republican contributions until after MaryAnn met with Nunn. Thereafter, on October 27, 1972, C-Tape made the following contributions: $150,000 and $27,500 in two separate checks to the National Republican Senatorial Committee, and $150,000 and $25,000 also in two separate checks to the National Republican Congressional Committee, for a total of $352,500. Footnote. On October 27, C-Tape also contributed $62,500 to the Democratic Congressional Campaign Committee and $47,000 to the Democratic Senatorial Campaign Committee. End of footnote. Lilly says that, as Secretary of C-Tape, he transmitted nearly all C-Tape contributions, including the two $25,000 contributions to the Democratic Congressional Committees, on October 17. Normally, he would have done so for the $150,000 checks to the Republican committees too. However, Lilly says that because the anticipated diversion of some or all of the additional $300,000 to the president's campaign was inconsistent with the policy adopted on October 11 by the Committee for Tape not to make any additional presidential contributions, Lilly refused to become involved in forwarding the $300,000 in contributions. Accordingly, Lilly sent only the smaller checks, $25,000 and $27,500, to the Republican Congressional and Senatorial Campaign Committees, while on the very same day, October 27, MaryAnn transmitted the $150,000 checks, together with his own cover letter, to the same two committees. Footnote. See MaryAnn Exhibits 4, 5, 6, and 7. 16 hearings 7354-65. The check to the Senatorial Committee was for $27,500, reflecting an additional $2,500 earmarked for a Republican senatorial candidate. Although the MaryAnn letters were dated October 24th, the $150,000 checks and the receipts were dated October 27, the date of Lilly's transmittal letters and checks. Lilly's secretary, Annette Tomasini, said in a staff interview that it was unusual not to combine the checks to the same committee on the same day. End of footnote. MaryAnn was unable to explain the reason for the separate transmittals. About a week after the contributions were sent, Lilly engaged in what he termed a, quote, heated discussion, end quote, about the contributions with Senator Dole, who at that time was chairman of the Republican National Committee. Lilly says the senator called him and indicated that he was very upset that the money was of no use to Republican senators because it had come in too late to be of any use in their campaigns. Although it was not expressly stated, Lilly believes Dole, quote, had some inkling in his mind that the money might not be available for senatorial candidates." End quote. The records of the Republican committees indicate that soon after the C-tape money was received, the following transfers were made from the congressional committees to the RNC and to the FCRP. 1. On October 30th, the National Republican Senatorial Committee transferred $65,000 to an arm of the RNC, the Republican Campaign Committee, RCC, and on November 7th, another $55,000 to RCC for a total of $120,000. 2. On October 31, the National Republican Congressional Committee transferred $95,000 to the RCC, and on November 3rd, another $6,000 for a total of $101,000. Footnote: Odell Exhibit 1, 16 hearings 7432. The committee records show that 3 checks were paid by the Congressional Committee to RCC, $95,000 on October 31, $6,000 on November 3rd, and $2,000 on November 20th. However, the $2,000 transfer appears to have been unrelated to the C-tape contribution. End of footnote. On November 7, the day the 4 transfers were completed, a financial arm of the RNC, the Republican National Finance Committee, RNFC, transferred $100,000 to FCRP, and on November 13, the RCC transferred another $100,000 to FCRP. Thus, within that 2-week period, just before and after the election, the 2 congressional committees received $352,500 from C-tape and transferred $221,000 to RNC committees, which in turn forwarded $200,000 to FCRP. Although MaryAnn denies knowing or approving of such a scheme, he does concede that he told none that the substantial additional contributions to the Republicans could be used to help in the presidential campaign, and that he made no such representation to Democratic fundraisers with respect to C-tape contributions to Democratic congressional committees in October 1972. Footnote: MaryAnn, 16 hearings, 7300, 7303-05, 7348. Although MaryAnn and several AMPI board members met with Senator McGovern in August 1972, and the senator asked them for their help, there is no evidence of any contributions directly or indirectly by AMPI or the other dairy co-ops or their political arms to Senator McGovern's 1972 presidential campaign. See Van Dyke, 16 hearings, 7007, 7009-10. End of footnote. MaryAnn says that the additional $300,000 was not part of an agreement with none, but reflected the desire by the committee for tape merely to have the contributions to Republican and to Democratic candidates at all levels equal for the 1972 calendar year. However, the prior contribution practices of the trust and the amount of the October 1972 contributions do not support MaryAnn's explanation. Over the years, AMPI's trust had contributed substantially more to Democratic congressional candidates than to Republicans, and as of October 11, the Committee for Tape had apparently been content to contribute an additional $50,000 to each side of the aisle, leaving total Democratic contributions for the year approximately 2.5 times as great as those to Republicans. There the matter stood until after Nunn solicited MaryAnn, who then instructed Lilly to make additional contributions to both sides, and, apparently for the first time, authorized the added $300,000 to Republicans. Had MaryAnn wanted only to equalize total contributions to all Republicans and all Democratic candidates for 1972, he could have accomplished this with an additional $170,000 to Republicans alone. Instead, he authorized $300,000 more, for a total of $352,500, and $109,500 to the Democrats, making the Republican contributions greater than the Democratic totals for the year. Footnote: by year end, total C-tape contributions to Republicans exceeded those to Democrats by about $20,000, even though there are perennially more Democratic incumbents, particularly influential congressional committee members from southern and farm states, seeking re-election than Republicans. End of footnote. As indicated above, Lilly says MaryAnn told him at the time of the transaction that the money was solicited and contributed in satisfaction of the prior commitment to the president's campaign for the 1971 price support increase. Like MaryAnn, none denies any scheme to funnel the C-tape money to the president's campaign. None asserted that the congressional committee transfers represented repayments of earlier loans from the RNC to the congressional committees discussed below. B. Prior RNC transfers to congressional committees. On February 16, 1972, Stans became chairman of the FCRP, and on August 20, 1972, at the time President Nixon was nominated for re-election at the Republican National Convention, he acquired the additional responsibility of chairman of the RNC. Although Stans did not make himself available for personal interview, his attorneys, in conference with the Select Committee staff, indicated that shortly after the convention, the chairman of the Republican Senatorial and Congressional Campaign Committees asked Stans for funds in view of their low reserves, and Stans agreed to make funds available to meet current needs. According to Edward Terrar, chairman of the National Congressional Committee, his committee had requested $600,000 from FCRP early in 1972, but the request was turned down at the time by Stans. Terrar says that just after the Miami convention, he was told that an agreement had been reached with Stans, whereby the RNC was to forego its share of the proceeds of a fundraising dinner, which would be split between congressional and the senatorial committees. Terrar said that Stans also made a commitment for an additional $200,000 to be transferred to the congressional committee, and that at the time the commitment had been mutually agreed that if the congressional committee accumulated a large cash reserve toward the end of the year, $100,000 would be refunded. On September 26, 1972, Stans, as chairman of RNFC, sent a letter to the executive committee of the RNFC asking for authority to transfer funds to the Senate and House campaign committees. He stated that those committees had not achieved their 1972 goals, and that at the time, RNFC had cash on hand above current obligations and necessary reserves. Stans asked for authority for the distribution of $140,000 to the Congressional Campaign Committee and $140,000 to the Senatorial Campaign Committee, quote, this being slightly more than our share of the gala in Miami Beach, end quote. He also asked for authority to distribute additional funds to those committees, to the Boosters Club, and to the CRP according to their needs. It should be noted that Stans' letter refers to, quote, contributions, subsidies, and distributions, end quote, to the congressional committees, but makes no reference to future repayment. The transfers were effected in the next several weeks. The RNFC issued a check for $140,000 on September 27, 1972, to the Republican Congressional Campaign Committee, a check for $140,000 on September 27, 1972, to the Republican Senatorial Campaign Committee, and a check for $50,000 on September 27, 1972, to the Congressional Boosters Club. The Republican Campaign Committee, an adjunct of RNFC, issued a check for $60,000 on September 27, 1972, to the Republican Congressional Campaign Committee, and a check for $60,000 on September 27, 1972, to the Republican Senatorial Campaign Committee. The Republican National Associates Committee, an adjunct of the RNFC, issued a check for $100,000 on October 9, 1972, to the National Republican Senatorial Committee. Thus, the RNFC transferred a total of $650,000 to the House and Senate Republican campaign committees from September 27 to October 9, 1972. Stan's attorneys say that it was understood that there would be some repayment of these very substantial loans when the cash position of the House and Senate campaign committees improved, and that the transfers following the C-tape contribution were viewed by Stans as partial repayment of the earlier transfers. Terrar could not recall the circumstance of the dairy contribution or the subsequent transfers, but stated that it was his belief that these later transfers constituted the $100,000 refund on the basis of their earlier understanding. According to Nunn, Stans, as chairman of both RNC and FCRP, had given his approval to the congressional committees taking the RNC share of the proceeds of a Republican National Convention dinner in August 1972, and that the several $100,000 transaction was considered a loan to be repaid by the committees when they had sufficient funds. When Nunn learned from MaryAnn of the intended C-tape contributions and informed Stans reportedly told Nunn, quote, to contact the committees and see if they can't make some repayment on the loans that we have advanced, end quote. Nunn thinks he then talked to the chairman of the two congressional committees and obtained their approval for repayment of the loans from the, quote, rather unexpected, end quote, milk contributions. He then instructed the employees of the two committees, Linda Clancy of the Senatorial Committee and Terrar of the Congressional Committee, to make the appropriate transfers to the RNC. Nunn likewise says he probably told Robert Odell, executive director of the Republican National Finance Committee, of the incoming payments, but does not remember giving him any instructions about retransfers to the FCRP. Nunn believes that such a direction would have come only from Stans, who maintains he must have authorized those transfers, but claims they were unrelated to the C-tape contributions. Other officials of the congressional and RNC committees provide a different account of the receipt of dairy money and the subsequent transfers. C. Other evidence of alleged pass-through. Nunn's position that the transfers from the congressional committees to the RNC represented loan repayments and not elements of a laundering scheme to FCRP is not fully supported by testimony from those committee employees involved in the transfers and by other evidence in the possession of the Select Committee. In addition, it seems to be inconsistent with other portions of Nunn's own testimony before the committee. The reports to GAO by the Republican committees involved in the transfers, the Congressional and Senatorial Committees, the RCC, and the Republican National Finance Committee, reflect the transactions as transfers, and not loans or repayments, and do not show any loans between those committees at any time in 1972. Moreover, the Congressional Committee employee who transferred most of the milk money was not made aware by Nunn or anyone else of any connection between the transfers and any loan repayments. Linda Clancy, a Republican Senatorial Committee employee since 1969, testified that on or about October 26, 1972, Nunn, whom she has known since 1969 when Nunn was executive director of the Senatorial Committee, called and told her that the Senatorial Committee would be receiving the $150,000 contribution and that there would be some, quote, help, end quote, for the committee from that money. Specifically, he told her to retain $30,000 and transfer the remaining $120,000 to an RNC committee in 2 installments, 1 week apart. $65,000 on October 30th and $55,000 on November 7th. Clancy says that Nunn made no reference whatsoever to any loans or repayments in connection with the transactions. Although Nunn claims he did not tell Clancy to transfer some of the milk money, he does acknowledge that he may have told her how much to keep from the milk money. Clancy says that she then called Odell of the Republican National Finance Committee to ask to which RNC committee she should transfer the $120,000. Clancy testified that although she did not tell Odell who told her to issue the checks, Odell appeared to know about the transaction and instructed her to issue both checks to the RCC, which she did. The others involved in the senatorial committee transfer of the milk money did not quarrel with Clancy's account. Buell Barrettson, executive director of the senatorial committee, did not remember the transaction when first interviewed by the select committee staff. When he was told by staff members of Clancy's account, he did not contradict her and said that he had not solicited the milk money and that he must have received his instructions for the transfer from either Odell or Stans. Clancy added that when she informed Barrettson in October 1972 of the transaction, he replied, quote, "At least we are getting $30,000. End quote. Although he does not remember speaking to Clancy or Nunn about the transfers, Odell testified upon hearing her account that he too had no reason to dispute her testimony. Although Nunn testified that he informed Odell of only the incoming monies from the congressional committees and not of the transfer to FCRP, Odell testified that both sets of transfers were probably part of one transaction. What's more, although Odell was aware of transfers from the RNC to the congressional committees in September 1972, shortly after the convention, he says, again in conflict with Nunn's account, that he has no knowledge that those September transfers constituted loans or that the transfers from the congressional committees to RCC following the C-tape contribution were connected in any way with those or any other prior transfers. No one connected with the National Republican Congressional Committee has any clear recollection of the reason for the $150,000 contribution and subsequent $101,000 transfers, despite the fact that the contribution would have been 10 times larger than any other contribution received that year. Jack Calkins, executive director of the committee, said in a staff interview that Edward Terrar, then finance director of the committee, solicited the contribution, but Terrar has no recollection of soliciting it or even talking to C-tape representatives. Sally Quinn, a committee employee for over 4 years, said in a staff interview that when the $150,000 C-tape contribution came in, Calkins directed her to deposit the money, and Terrar instructed her to draw the checks to RCC. Terrar says that, although he is fairly certain it was not Nunn or Stans, someone must have told him what to do with respect to the checks, and as noted in the previous section, he explained that the transfer was to repay earlier transfers from the RNC. However, Quinn, who was responsible for preparing the committee's financial statements, says she knew of the earlier transfers from the RNC to the committee, but not of any obligations in connection with them. Nunn's explanation for these transactions is at variance with other portions of his own testimony. It should be recalled that Nunn had solicited money from MaryAnn for Republican congressional candidates who, he told MaryAnn, were in need of money in the last days of their campaigns. Yet, even before the money came in, he had taken steps to withdraw most of that extra $300,000, thereby denying it to the congressional candidates he said needed it. When presented with this contradiction, Nunn conceded that he did not know how the C-tape contributions benefited the congressional campaigns for which they were supposedly received. In fact, contrary to Nunn's representation, Odell testified that his committee had exceeded its fundraising budget by that time, and, in any event, money coming into the senatorial campaign as late in the campaign as the C-tape money did, that is, about 1 week before the election, could not be used judiciously by the various congressional candidates. Footnote: Odell, 16 hearings, 7428-7430. Nunn, who referred to Odell as, quote, fairly well experienced in political campaigns, end quote, especially in finance, disputed Odell's opinion. Nunn, 17 hearings, 7541-62. End of footnote. Neither did the RNC need the money, which, according to Stans, had accumulated a surplus of over $500,000 before the milk money was contributed. Indeed, of those Republican entities involved in these transfers, only FCRP allegedly had a projected deficit, as well as what Odell considered a, quote, judicious, end quote, use for the unexpected last-minute C-tape contributions, payment for the previously scheduled pre-election media campaign by the November group. Finally, Nunn conceded that no transfers would have been possible without the milk producers' contributions. The milk money evidently did make it possible for the two committees to make a substantial repayment of their loans. It was truly milk money that made those repayments, because, unless those contributions had been received, they couldn't have made them. While Nunn's explanation that the transfers constituted repayments of prior loans would account for routing the money from the congressional committees to RNC, it would not account for the subsequent transfer from RNC to FCRP or for his representations to MaryAnn of the financial need of Republican congressional candidates. It appears then that Nunn, who had shepherded the funds from the milk producers all the way to FCRP, and who was one of the top finance men in the campaign involved in all facets of campaign fundraising, must have been aware, when he spoke to MaryAnn, of the financial condition of the various Republican entities, and had anticipated the path the final dairy $300,000 would take. Furthermore, as was the pattern in most milk producer contributions to the president's campaign, these contributions were accomplished with a minimum of public detection before the election. All of them took place either after the last pre-election reporting date or after the election itself. Footnote: as noted above, the final pre-election report was due on November 2, 1972, for transactions on or before October 26. The C-tape contributions and subsequent transfers were made thereafter. End of footnote. In all, contributions from the milk producers made available for the president's campaign totaled some $632,500. Footnote: this figure consists of the following: Kalmbach, 1969, $100,000. Presidential Committee, 1971, $237,500. FCRP and Democrats for Nixon, 1972, $95,000. Additional C-tape fund, October 1972, $200,000. Total, $632,500. This amount does not include $95,000 to non-presidential Republican committees, which is a part of the total presented by the White House in its white paper. End of footnote. They began within weeks of the birth of the Nixon administration in 1969, when the milk producers were proposing large contributions to press their views for higher milk price supports. There is evidence that 3.5 years later, at the close of the 1972 presidential campaign, they were still furnishing campaign funds to satisfy a commitment dating back at least to March 1971, at the time of the controversial price support increase granted by the president. End of Section 38. Recording by Greg Giordano, Newport Richey, Florida. End of Final Report of the Senate Select Committee on Presidential Campaign Activities, Volume 2.